What is the suit for? Yes. Monday.
Because the matter was posted on 6 for hearing an amendment application. Suit itself not is dismissed as not maintainable. Intention granted by the trial court confirmed by this court. Suit itself not in the matter. Issues are not present. Matter posted on 6 for hearing or application. Suit itself.
No, what applications?
Amendment of 6 on 70.
Dismissed on what ground?
Suit itself has not maintainable. Intention should not maintainable, especially for corporate software.
Monday.
Not tomorrow, selling the property, paper publication.
Monday. Yes. Yes.
So, the final take proceedings has vacated, my lordship. It's an appointment of court commission application as well. They will take up on hand.
Tuesday. What is the suit for? Suit. What has happened in the suit? Yes. Monday. Yes. What is that matter? Tomorrow. This matter has to be heard finally if interim order is vacated. Yes, next week. Yes, next Tuesday.
Page wise adjournment. Page number 1, serial number 1 to 3. Page number 2, serial number 4 to 7. Page number 3, serial number 8 to 10. Page number 4, serial number 11 to 14. Page number 5, serial number 15 and 16. Page number 6, serial number 17 to 19. Page number 7, serial number 20 to 23. Page number 8, serial number 24 to 29. Page number 9, serial number 30 to 36.
36. 0. Yes. Yes. The request of counsel for the appellant. Leave this matter of 2 weeks. Which is that connected matter? What is that connected? On same suit, 2 IA has been filed. Yes. The net counsel for the appellant says this appeal may be called along with that so and so. After 2 weeks. Yes.
Page number 10, serial number 37 to 41.
Serial number 14.
Don't Prasad.
The request of counsel for the appellant, please this matter of 2 weeks. Yes.
Yeah, Subramanian.
Yes. You are appearing for? What is that? Have you informed other side? Inform. Yes, at the request of counsel for the respondent, please this matter of 2 weeks.
Page number 11, serial number 42 to 49.
Serial number 42.
Yes.
Member expired. The second is service of senior counsel.
42 at the request of counsel for respondent, please this matter next week.
47.
2 weeks.
Serial number 47, representing except Suraj.
Hmm.
He's out of station, that so I requested to take 2 weeks time.
The request of counsel for the appellant, please this matter of 2 weeks.
Please.
Page number 12, serial number 50 to 55.
Serial number 53, my lords,
Yes.
for the respondent.
Yes.
There's also another connected matter.
Hmm.
2 weeks adjournment.
At the request of counsel for the respondent, Pradeep C. Yadav, use this matter of 2 weeks.
Let's 52.1, my lords, I am appear for the appellant.
Yes.
Kindly have it after 2 weeks, my lords.
Now that service is not completed,
The court fees on ಕಟ್ಟಬೇಕಾಗಿದೆ ಇನ್ನ ಬಂದಿಲ್ಲ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ informed.
then why you have connected, Mr. Without complying that office objection, unnecessary, you are dragging that other matter also.
I have not connected, my lords.
Then I will dismiss it. You have not completed that court fee.
1 week time ಕೊಟ್ಬಿಟ್ಟು conditional order ಮಾಡಿ sir.
Last time also same thing. Yes.
So
At the
it is
request of counsel for the appellant in MSA 127 of 2021 as a last chance, week's time is granted to comply that objection. Yes.
My lord, appearing for the appellants, my lord.
Yes.
In this case, I pray for a 2 weeks time to take steps. And with regard to R10 to 12, my lord may be taken as served because they have unclaimed the notice which has been sent from this honorable court.
Including R10 to 12.
R10, Sarojamma.
Yes. Mili. Baranga.
Rukmini. The door lock. Panduranga. Intimation delivered on customer.
Not claimed.
Unclaimed. Panduranga unclaimed. Sir, door lock. Second time intimation. Sarojamma. ಅದು intimation delivered ಅಷ್ಟೇ.
ಇವ್ರು unclaimed ಅಂತ ಯಾಕೆ ಬರೀತಾರೆ?
ಸರಿ ಅಣ್ಣ.
Also, let us say verify that it is not that in all cases they are unclaimed there.
Oh, oblige, my lord. Oblige.
Yes, Mr.
Memo. The respondent number 2 and 3 are the loss of the deceased respondent number 1.
Yes, who are that LR?
Children of the deceased.
They are the children.
Before the trial court.
Yes.
They are the trial.
Now that who is that Vasanta?
Vasanta is dead.
Lalita and Satish are that LR
Children.
children. Yes. The net counsel for the appellant has filed a memo stating that the respondent number 2 and 3 are the only LRs of deceased respondent number 1. The memo is taken on record. The respondent number 2 and 3 are treated as a LRs of deceased respondent number 1. Learned counsel for the appellant is permitted to amend the prospect.
Another of the subsection
Hmm.
that I have not served the notice of the counsel who represent the respondent. Yes, sorry.
Yes, learned counsel for the appellant has filed a memo stating that office objection has been complied. Submission is taken on record. The office objection is overruled.
My lord, that respondent number 1 to 3 has been received.
Hmm.
Others has not received, but anyhow, the notice has been served on this.
Now that it is served,
Served. It may be
yes. Now that office objection is overruled.
over. Yes. My lord, petition.
No, it is not yet admitted. Yes, suppose this
the
matter
short
for.
question is that the expert day order has been passed, so
Hmm.
hearing me,
Hmm.
has to be remanded back.
Yes, who is other side?
Others said they have been served, now they are not.
No, that Muniraju is there. 2 and 3. Yes,
Yes,
Munir.
yes.
Who is
The
that?
date may be fixed.
Serial number
Next
2,
week.
yes, Muniraju.
Was this matter for admission next week?
Yes, yes.
15.
Number
15.
serial number 3, Irfan Nazir for appellant.
Referring to the appellant and the sponsor.
Hmm.
But the office objection is that we have paid the court fee in excess.
Hmm. Value of the appeal to be stated correctly. Deposit court fee to be made good.
Paid the court fee, actual court fees of 18,000. Paid at court fee, amount DD of 8,000. We recommended the-
No, they said that deficit. It is not higher. You have paid more.
A week's time.
Yes, week's time is granted. Comply that office objection.
Serial number 4, Natarajan MC for appellant, Dinesh F. Adlas.
Non-compliance of the office objections for second time. What is this, Mr.? Yes, week's time is granted. Requested by the appellant to week's time to comply that office objection.
Serial number 5, Manian KBS for appellant, Arun DM.
Yes.
Be listed for hearing on the interlocutory application on merits.
No, that's what today. Not final. You argue on that. You see, limited interim order has been granted. Now it is for extension. You make out in a case for extension. Otherwise, whatever that order court has to ask, you have to take. Yes.
In that context, and all agrees with me. This matter requires consideration. Hearings are not complete on the last.
No,
hearing-
For application, consideration of interim prayer, pleadings, completion of the pleadings is not necessary. On the basis of that appeal memo, after hearing the parties, I have to be considered for interim prayer. Yes.
The interim order has been extended even after the counsel for the other side of the appeal.
That is, yes, it is
Therefore-
limited. Are you interested to argue on that interim applications? Or
Coming to that.
Yes.
Because an interim order was passed by the Honorable Court.
yes,
Was extended on two or three occasions.
yes,
They have not filed any objections. Nothing is on record. As of today, as I argue this matter on the record of the court, there is nothing on record which puts me in a position to satisfy the court why it should not be extended, unless my friend was able to show on pleadings why that order should not be extended. I mean, I'm just putting it in the court. What should I respond? I mean, on the basis of my writ petition and the submission that I made, this court was placed to grant me an interim order.
yes.
Council appeared on 20th of January 2023, on which date the pleadings of the appeal was submitted to him. We are today on the 9th of February 2023. The matter came up day before yesterday, where I made a fervent request to the court that the learned counsel for the respondent was making submissions off the cuff, referring to Supreme Court judgments, etc. Unless that is put on record, I mean, end of the day, law of pleadings is you put the other party on notice so that he can answer your claim. You don't want the interim order to be extended, you say so, and then I will meet it and then the court will be satisfied whether I'm able to. Now,
No,
my
no.
lord is asking you to justify the extension without there being nothing on record.
No. I will ask first. See, he need not place that Supreme Court judgment or that has been considered by the trial court. when that interim order has been granted, you misleaded the court saying that Supreme Court has granted an order in your favor. I will hear that. You argue on that. On that day, you have made a submission, urgency. You said that Supreme Court as well as that Madras High Court order is in your favor. In fact, it is against you. I have gone through that file. You argue on that. I will hear.
Where are those orders, my lord? I have not served the orders.
No, it need not be. That is the order which is considered by the trial court after hearing your counterpart
I
there.
hope, I'm request to the honorable court is,
Yes,
I
I
hope
will.
I'm not already made up his mind.
Yes,
I
yes.
mean, the way the response is coming, with due respect,
Yes, yes.
I hope I'm already not, making any submission.
Now that you argue on that your
No,
interim.
since my lord has something in mind, which
Yes.
obviously I may be wrong and my lord may be very right,
Yes.
and serious allegations are being made across the bar at me for having suppressed facts, which I'm totally at loss to understand. Fair procedure would require that the judgment which my lord is referring to, I be put on notice of it. The thing which my lord is complaining that I suppressed, which I'm not aware of even till today. May I?
No,
at least-
Mr. That is the reference which is made in the trial court order that you have challenged. You may not be aware, but your counterpart is aware. That has been referred.
No, 1 minute.
You-
1 minute.
No, that is it. That
It
is
can't be both
no.
of you guys against me.
no, that is no, Mr. Mani. I think you both are appear there.
Sorry?
You both are.
No,
appear.
I still am at loss to understand the allegation.
No, now that you
Don't
forget
cut me off
everything,
like this.
you argue on that interim
Ask
application,
on what?
continuation of interim application, interim prayer.
May I know why it should not be continued?
Yes,
Unless he points it out, then I can say.
yes. Now that he has to argue that why it is not be continued. Yes.
Before he argues, may I make the submission to the court?
Yes.
Can he put it in writing so that I can take instructions from my client? So that I can answer, isn't that the basic principle of law of pleadings?
Yes.
I mean, may I make, if my lord is accusing me of having suppressed facts. I'm only a counsel on record. If my friend is putting on record something which he alleges that I've suppressed from the court, it may be that my clients have not informed me of those facts. I need to take instructions from him. I mean, if it's blatantly on black and white, then I can address the court. But even to know whether there has been a suppression black and white, I need to know what.
No, I am not considering all this. Let him argue what is the ground for not extension. Then you give reply.
No,
then-
may I make the submission to the court?
Yes.
This matter has come up on 50 hearings.
Yes.
Is there a terrible hurry that it should be taken up today? Can a date be fixed where we can hear this on merits?
It
Is
is
the court, I understand that is a looming large. Court respondent is retiring tomorrow. Is it that this matter is being taken up only for seeing that that man continues in office?
It
If
is
that
not
is so, may I make the apprehensions addressed to the other side? That on merits, if the court comes against me,
yes.
he can be put back in office. We are not trying to steal a march on the other side.
No, I am not passed any order. Let him convince the court that why.
But should he not file an objection? I've never heard of a procedure where the court has granted an interim order, the other side is served long back, and he would make submissions off the cuff without nothing on record. How am I to understand that?
Yes.
May
Yes.
I make the request that at least we should be able to understand on the matter of procedure? May I make the submission?
Yes.
I think much is said today. What I will do is, if my lord is not inclined to extend an interim order, for reasons which I am surprised, that my lord made a
No,
submission.
I have not
You
seen.
made an observation across the bar
Yes.
that you have some information in your mind, according to which I have suppressed facts. That is very damaging to me because I stand corrected then. If it is suppression of facts, my lord, I would tender an apology because I've been
No,
misled.
that's, no, Mr.
What are the facts suppressed?
No,
Can we-
see, Mr. That is not taking into the consideration of that. No, now I will decide on that submission of the
No,
party.
my lord has, obviously with due respect, my lord's mind is now prejudiced against me because my lord
No,
has made an
no.
open submission in court.
It is not
that
for
I have
this.
suppressed certain judgments.
No.
I have all my experience at my command. I've never, in all my 30 years of experience, have indulged in suppression of a judgment from a court of law. My lord has made a very serious allegation against me, which may be true. And if it is true, I need to tender an apology to the court.
Yes, no, Mr. Mani, that will not take into that consideration of that interim for hearing the parties. On that day, you have made an urgency, even there is an office objection is there. On the basis of that your submission, I have granted an interim order for a limited purpose. Now on the appearance,
My
I
lord,
will
may I
consider.
make the interim order of court? Yes. My lord, may kindly have a look at the interim order passed.
Yes.
I mean, can I just ask for, I understand there are other matters
No.
No, can it be taken after it should come interoccupy, 2:30.
2:30.
Yeah.
That's yesterday, what happened, I have a copy on him. You cannot say I have not served a copy on him.
No, see, it is not that. Now that court has granted an interim order. Now it is for an extension. If we have any objection, I will hear and pass an order.
It is an MFA, I'll argument.
Yes, sir. It is only for the consideration of interim price. Whether if you make out a case, it will not be extended or it can be modified. Or if you make out in a case, it will be
My lords,
extended.
after my lords attend the matter day before yesterday. Yesterday press conference was held in the press club stating that this court has granted an order to Garba
One minute.
a meeting. That is not the order of this
No,
court.
that all that it cannot be.
No, he has a lot of, he's not anything on record.
No, mister, I am not on that.
No.
It is only on this case. Yes.
Ma'am, I will rely upon the Supreme Court judgment of India and the Supreme Court judgment of the United States on how these matters have to be dealt with. I
No,
mean,
mister, if you make out in a case, I will extend it.
my lord, there is an interim order passed by this court.
Yes, 2:30. Yes, 2:30.
Number 6, Sanjay, you for appellant.
Yes. Yes, mister.
Building bylaw matter, my lord.
Whether a suit for, whether an injunction can be granted by the civil court for a violation of the building bylaws.
Yes,
I refer to the judgment of the coordinate bench of Justice Purachan,
yes.
which held that solely on that ground it would not be permissible. I've also brought it to the notice of this honorable court. So far as air and light is concerned, Chapsi Bai's case clearly spells out as to what is the consideration or the finding which the court should come out with, which finding could not have been recorded because there was no pleading essentially regarding that. So then, Learned said that he wants to see whether the suit could still be maintained.
Yes, it is maintainable.
Suit is maintainable.
No,
Whether
really,
in the
injunction
suit,
can be granted for the violation of building bylaws
Yes.
because
that is,
imposition of the bylaws and the remedy under for the purpose of violation of the bylaws is an aspect which is covered under the provisions of the BBMP Act, the present BBMP Act.
no, that's what the judgment said. In suit for easementary right, court cannot be relied on that violation of that building bylaws.
Yes. My lord, please see that judgment which my learned friend is relying upon in Sundar Raj's case itself.
Yes.
Lord, if that judgment is there with my lords. 2001, one Karnataka Law Journal, 648.
Correct.
ILR report.
Yes.
460.
Yes.
Lord, please see the eighth para. Eighth para, my lord,
Yes.
begins with the wordings in the light of these two rulings. My lord, two rulings are relied upon.
Yes.
Para 8, my lord, I have the SCC version.
Yes.
My lord, it starts with in the light of these two rulings.
Para 9 of the judgment.
Then I
Yes.
think it is para 9.
Yes.
In light of these two rulings, it is clear to me that no injunction can be granted at the instance of a neighboring owner unless the violations, deviations of license results in injury or a right as held by this court in the above two judgments. Admittedly, in the case on hand, the plaintiff owner has failed to prove prima facie an injury or violation of a right in his favor, and this aspect has not been considered by the appellate court. Therefore, in my view, the trial court committed a serious error. I make it clear that not in all circumstances a neighboring owner cannot approach the civil court for injunction. A neighboring owner can seek an injunction against his neighbor for violation of a building plan or a license or laws, subject to the condition that such violation has resulted in violation of his right or causing an injury to him on account of such deviation or violation. So therefore, in some cases, they say it is applicable. But what they say is a neighboring owner can seek an injunction against his neighbor for violation of a building plan or a license or loss. So the word is or. So therefore, if I am able to satisfy any one of this, I am entitled to seek for injunction. So this judgment does not say that based on this suit is not maintainable or a neighbor cannot ask for an order, interim order. Then my lords may kindly see.
Yes.
There have been judgments of the other courts where on this aspect of the matter, this is a judgment which the trial judge has relied upon for granting an injunction. It is referred to in the order also. This is 1995 SEC online Rajasthan 281. Impugned order leader. This is something that was placed before the trial court.
Yes.
Reference is made to Ramdas Shenoy's case versus Udupi, that is 74 Supreme Court 2177.
Yes.
Please see para 11 onwards.
Yes.
12. In my considered opinion, in order to make out a prima facie case necessary for granting injunction, the plaintiff prejudiced need to establish his title. It was sufficient. He can't satisfy that the disputed open land should be so on and so forth. The second consideration which every civil court is required to keep in view is that in such cases where existence of light and air is claimed, if the defendant opposite party is allowed to raise construction, the very circumstantial evidence of getting light and air will be destroyed. It will not be possible for the plaintiff revisionist to establish that he was getting light and air from the open disputed land. It is a matter of common knowledge that every municipal council has framed its building bylaws, and as such, in disobedience of such building bylaws framed by the municipal board, a person is not entitled to raise construction. To my mind, the object of the building bylaws made by various municipal boards in the state of Rajasthan are to keep the environment clean by providing sufficient air and light, not only to the owner of the house, but also persons residing in the locality. If a person is allowed to commit a breach of the building bylaws of the municipal board by his acts and omissions, it must be deemed that he intends to affect the environment. It should not be permitted. An illegal construction of building against bylaws of a municipal board materially affects the right of enjoyment of the property of persons residing in the locality. Then, my lord, they refer to the apex court judgment where it went from our own high court,
yes,
where illegal construction of a cinema building was stopped by the apex court. That is what they refer to Ramdas Shenoy case.
yes.
An illegal construction of a cinema building materially affects the right of enjoyment of the property by persons residing in the residential area. Of course, there it was construction of this thing. The crux of the matter that I am submitting before my lords is building bylaws are made with a certain purpose. One of the purposes is that both the owners, neighboring owners, are able to reside peacefully. That is why this concept of setback, what is the height of the building, are all brought into existence.
Yes.
Now, my learned friend, as a matter of principle, cannot say, I will violate it, I will construct it. And then if the court finds that there is light and air that is affected, I will remove it. Then the sanctity of issuing such building bylaws goes away. Every person tomorrow will say, I will violate it. If tomorrow something is found to be wrong or illegal, I will remove it. The law requires that things must be done in a manner fixed by law. Things must be performed in a manner prescribed by law. Persons cannot be permitted to say, I will violate it, I will do it. Tomorrow at my cost, I will remove it. So this is what is happening, my lord. Here, then they also refer in para 17 to two other judgments, particularly judgment of the Sikkim court, which is followed by a lot of courts. Please see para 17. In Srimati Lammu versus Ladena, AIR 1983 Sikkim 5, the plaintiff was granted an injunction against his neighbor defendant who was constructing building contrary to the bylaws of the municipalities. From these authorities, it appears that the plaintiff has a right to seek the aid of the court in restraining his neighbor from raising construction contrary to bylaws or from raising unauthorized construction. Raising of unauthorized construction will affect the rights of the plaintiff, as under the building bylaws 1983, leaving setbacks is mandatory. Admittedly, there is no sanction plan in favor of the defendants. They have not made any application for obtaining any sanction for raising a building. still their intention from the report of the local commissioner is clear that the intent to raise structure, such a structure cannot be raised without permission. Now here there is a building plan, but if they are raising constructions beyond what is sanctioned in the building plan, it is again not authorized. There is no plan for that, and therefore they should not be permitted to violate. So therefore, now my learned friend cannot say that this court has no power or jurisdiction to give a fiat to him or to direct him to put up construction strictly in conformity with law.
Yes.
Now, what is it that I am requesting? That he must put up construction in conformity with law. If he puts up construction in conformity with law, all the problems are solved. He cannot say, I will violate it, I will put up tomorrow, you establish. It is like putting the cart before the horse. So therefore, this judgment which my learned friend relied upon and said that the court cannot direct that I must put up construction in accordance with law and no injunction can be granted is not, that is not the case. Then we see why this was done in the peculiar facts of this case. May I request my lords to kindly come back to Sundar Raj's case again.
Yes.
I think para 10, my lord, it begins with the learned counsel appearing for the respondent has relied upon a judgment. Para 10.
Yes.
There, my lords, after referring to various judgments of the Supreme Court and other judgments, my lords may kindly take about 8-10 lines from the top. Moreover, in the case on hand, no doubt the judgment of the Calcutta High Court in Krishna Kali Malik versus Babulal Shah provide for an injunction in the event of construction in violation of the statutory rules. But the relief has to be given, as I mentioned earlier, in the earlier paragraph, only in the event of violation of a plan or a license resulting in an injury or violation of a right in favor of the neighboring owner. Practically all the high courts have held, my lord, that it can be granted. Now, coming to the facts of this case, therefore, the counsel for the appellant is right in his submission with regard to right of the party in the matter of injunction in the light of these two judgments of this court. Moreover, in the case on hand,
Where are you reading?
my lord, there is a reference to Calcutta High Court judgment, my lord, Krishna Kali Malik versus Babulal Shah in para 10.
Yes. That you have read that
provide for an injunction in the event of construction in violation of statutory rules. But that relief has not been be given, as I mentioned earlier in the earlier paragraph, only in the event of violation of a plan or license resulting in an injury or violation of right in favor of the neighboring owner. Therefore, the counsel for the appellant is right in his submission with regard to a right of the party in the matter of injunction in the light of these two judgments of the court. Moreover, in the case on hand, the trial judge, in my opinion, has committed a patent error in granting an injunction even on merits. It is the case of the plaintiff that the free air and light is affected on account of the said construction. Learned judge himself in para 10 notices, no construction is put up in the sites owned by the plaintiff. So that factual situation was entirely different. There is no record to show that flow of air and light is prevented. Here, building has come up.
Yes.
Having come to this conclusion, the trial court ought not to have granted an injunction. So on that ground, the court interfered. An interim order is granted to arrest an imminent danger or injury to the contesting party. Any interim order has to be in aid of the main relief. But when there is no imminent danger or injury, no temporary injunction can be granted by the court. It is under those circumstances, my lord, this honorable court intervened because it was a vacant site. Here, I made complaint when the basement was coming up. I said, please leave the requisite setbacks because basement will not affect my light and air, as the court has said. It is only when construction comes up to a certain level I can complain at it. At the earlier stage itself, I have complained. I approached the neighbor and said, please leave the setback. So this case, the facts are different. And as a matter of principle, my learned friend cannot say that this court cannot ask him to obey the statutory rules. It is something unheard of. So therefore, when there are statutory rules, building bylaws are there. There is a sanctioned plan which says that this must be the setback that must be left. Practically all the courts in the country have said when there is a building plan or a sanctioned plan and there are building bylaws, construction has to be put up in adherence of that. No court can, my lord, say that please deviate from this and put up construction. Rest of the things will be considered later. So what I am submitting before my lords is If my learned friend's clients were to put up construction in accordance with sanction plan, it will be to the aid of his client. Construction will be in accordance with law. I cannot have any grievance.
Yes.
And I have shown to my lords on the previous occasion where 3.5 feet setback is to be left on my side. 10.5 inches is left. If 3.5 feet is to be left, he leaves 3 feet. There is some marginal infraction. It is a different case. There can be no comparison between 3.5 feet and 10.5 inches. So therefore, the injunction that is granted by the trial court is strictly in conformity with the rules, statutory rules, building bylaws, and the facts and circumstances of the case.
Yes. Yes, Mr.
Can they have a look at Sundaraj's case, please?
Yes.
Really pardon me from being repetitive because I want to make it a point. Paragraph number 9.
Yes.
In the light of these two rulings, it's clear to me that no injunction can be granted at the instance of the neighboring owner unless the violation, deviation, license results in injury or a right as held by the court in these two judgments.
Yes.
Admittedly, in the case on hand, the plaintiff owner has failed to prove prima facie injury or violation of a right in his favor, and this aspect has not been considered by the applicant. Therefore, in my view, the trial judge committed a serious error to make it clear that not in all circumstances, neighboring owner cannot approach the civil court for injunction. Neighboring owner can seek an injunction against the neighbor for violation of the bidding plan or a license or loss subject to the condition that such violation is resulted in violation of his right or causing an injury to him on account of such deviation violation. So I just pause here for a moment. My grievance is also the same, that it is not that under all circumstances you should not approach the court. He has specifically approached the court saying that my air and light is affected. Now, until and unless the court records a finding that is air and light in the tenor in which it is required to be established or period is injured or is affected, question of granting an injunction for a mere violation of the bidding bylaws would not arise. That's the summons of. Now, kindly have a look at paragraph number 10, which further clarifies this issue. Yes. This is not the view taken, Lords, by the coordinate bench as for the first instance. There are two other coordinate benches judgment which was relied upon by Justice Gurraj. Kindly have a look at paragraph number 10. Yes. The learned counsel appearing for the respondent has relied upon the judgment of Fakirappa to contend that injunction can be granted in the instance of the neighbor. That was a case clearly distinguishable from facts. In that case, the High Court found that evidence there was factually violation of by the party in the matter of construction. It is further found that the permission granted by the corporation was quashed by the High Court. It was in those set of facts that the court ruled that injunction can be granted. That was not the case in the present part. Let's kindly mark the next sentence. Therefore, the said judgment cannot be relied upon with the defendant to seek an injunction. In the circumstances, I am of the view that no temporary injunction can be granted at the instance of a neighbor on the sole ground of violation of the sanctioned plan or the building by law. As rightly held by this court in Patran Naik Supra, that when there is a violation of bylaw and appropriate court can direct the commissioner to take action or a complaint to him on this behalf. The act itself provided a complete machinery to inquire into the grievances. At the same time, I clarify that in the event of such inaction on the complaint by the neighbor of a violation on the part of the municipal commissioner, the parties are able to seek remedy to take action against the erring party. Merely on a complaint to the commissioner, merely on the ground of violation of bylaws as rightly held by this court in Patran Naik's case Supra, no injunction can be granted since a comprehensive machinery is provided under the municipal laws. This is actually the law. This is not that it is stated for the first time by Justice Gurraj. This is reiterating what has already been held. So this is the law which is applicable.
Now, both is there. If there is a violation, if it is at a effect, the right of the neighbor cannot be granted. Then other part it is said, it is separate mechanism has been.
What should coexist? It is now what they are saying is,
yes.
I can't walk into a passport office and ask for a postcard and vice versa that I can't walk into the post office and say that I want a passport. It's not possible. Now, if they want comprehensively both the things, then what is the requirement of establishment? Assuming that there is any violation of building bylaw, which forms the sole basis or the sole ground on the basis of which the injunction is now granted. Now, kindly have a look at Chapsi Bai's case.
See, just because there is a violation of building bylaws,
yes,
no injunction can be granted unless it is effective is right under the. Suppose he is in the left side, you are violated right side, cannot be granted. That is what that said. Here, if it is violated his rights, he can approach.
Now there is a question. Now, violation of air and light. How violation of air and light takes place? That is covered under section 3 of the easement side. Section 33 says, what is the nature of infringement which can be complained of, create a cause of action to complain an injury that such an air and light is obstructed. Yes. This is essentially not what is the pleading is to be forthcoming. I can say so without a fear of contradiction.
Yes.
The pleading does not put forth a plea
Yes.
that air and light is affected, or the free flow of air and light is affected to an extent that habitation has become impossible. That is a requirement under law. There is not even a pleading, so therefore, question of giving a finding to that in that regard would not arise. So kindly have a look at the Chapsi Bai's case.
Yes.
1971 volume 2 SCC page 205.
I furnished that.
I have furnished the judgment. Sorry, not because
It is there, yes.
please.
Yes.
Kindly have a look at paragraph number 22.
Yes.
As the light and air through the windows on the western side, what are the nature of pleadings which is required? I just pause here, before I complete reading paragraph number 22.
Yes.
They should say, these are the number of windows which is there on the eastern side. This is how I am getting air and light. And the manner in which the construction is put up, it will completely block the air and light in a manner that the human habitation becomes impossible. This is essentially the requirements to be pleaded in an easementary suit. Now, kindly have a look at paragraph number 22. As the light and air through the windows on the western side, it is clear from explanations 2 and 3 of section 33 that to constitute an actionable obstruction of the free passage of light or air to the openings of a house, it is not enough that the light or air is less than before. There must be a substantial privation of light, enough to render the occupation of the house uncomfortable according to the ordinary notions of mankind. Yes. This is not the pleading. And I will say so without any fear of contradiction. Yet again, that the trial court records a finding that as to whether there is an infraction of his right of air and light is a matter of trial. I am not going to give a finding on this. But the coordinate bench's view taken is that unless you give a finding as to whether there is an infraction, it would not be permissible for you to grant an order of injunction on a simpliciter ground or a sole ground that the building bylaws has been violated. This is not the law as it is developed. And we also referred, we said, now you file an application for injunction. If construction has come to a particular stage, I said any further construction which I put up will be in accordance with the sanction plan. This is a concession which I am giving, which I am not required to give under law because there is a separate machinery there now. What stood under the BPMP, what stood in the Municipal Corporation Act is materially different in the manner in which it is drafted in the BPMP Act. We have got leverages for regularization. These are all indirect means and methods which is provided for regularization of the new BPMP Act. It's a different matter. But I am making a statement that any further construction which I put up will be in accordance with the plan. And whatever constructions which has already been put up, it's obvious that these are the constructions.
No, we don't know whether you have put up in accordance with law or not. But we will say that you may be permitted to construct in accordance with
further construction. Now, what I am submitting, further construction. Now, the difficulty belongs what? This is where we got stuck on the last occasion. Now, a construction has come up to a particular stage. There is no mandatory injunction. Court observes that the 2 floors constructions has already come up. Now, after that, the injunction of the court operates beyond that 2 floors because the court's injunction is don't put up further construction. That is what essentially the court has directed. And now making a statement that whatever is constructed, that for that there is no order which is now under challenge at your lordship stands or that your lordship is going to pass any orders on that. Any further construction to be put up by me in addition to whatever was there as on the date when the injunction was granted, I will put up in accordance with the sanction.
yes.
Lord, kindly see, his first part is incorrect. In para 7 of the plaint, have clearly said,
Yes.
it is now well recognized that the right of peaceful and meaning residence existence is clearly a part of fundamental rights, that is the right to life.
Yes.
In other words, the law should come to the aid of the person whose very livelihood is being affected severely on account of the illegal construction, which is also impairing the easementary rights of the plaintiff. Para 7
Para 7 at page 59.
Yes, yes.
Yes, law should come to the aid of the person whose very livelihood is being affected severely on account of the illegal construction, which is also impairing the easementary rights of the plaintiff. It is a case where this honorable court will have to intervene and uphold the majesty of law while also protecting the rights of the plaintiff. Hence the present suit. So therefore, livelihood is affected is pleaded. So my learned friend cannot say that there are 4 windows, 5 windows. That is not the case here. The facts are entirely different. What I have said was that there was a sheet roof house which was demolished, and now there is a huge structure that is coming up. Chapsi Bai's case was different. They wanted to open more windows, and that is how that case was seen. The law will have to be seen in the facts and lights of each situation. Now, the construction, my lord, is they have to put up in conformity with law. Now, if they say further construction is to be put up, we don't know what construction is put up. He may say this construction was put up earlier, it is not being put up now. He may still continue to violate it.
But sir, and take photographs of what the status of property is today. So the last year, he have produced the photographs. Any further construction? So now that he has made the statement, it becomes difficult for him to get out because para 11 of Sundar Raj's judgment addresses this issue also. Moreover, in the case on hand, kindly have a look at exactly the same facts which were pleaded in the earlier case, paragraph number 11. Moreover, in the case on hand, the trial judge, in my opinion, has committed a patent error in granting an injunction even on merits. It is the case of the plaintiff that free air and light is affected on account of said construction. The learned judge himself in paragraph notices that no construction is put up in the sites owned by the plaintiff. There is no record to show that the flow of air light is prevented.
He was not reciting there.
Having come to this conclusion, the trial court ought not to have granted an injunction.
Correct.
What I am submitting is, say, it is not that air and light is there everywhere. You can't prevent it. But when you are saying that there is an enjoyment which is on a particular site, you should say how you are enjoying this property which is conspicuously absent. Now, kindly have a look at paragraph number 7 of the plaint. Yes. In the teeth of what was said by the Supreme Court in Chapsi's case. Page 59. If this constitutes a pleading at all, if I am constructing any construction on his property, then the situation would arise as to whether, kindly have a look at page number 58 of the paper book, the plaint is produced. For 4 lines, the photograph shows that hardly any setback area is left to the western side. First defendant intends to construct a 3-story building on the Schedule B property.
Where you are reading?
Para 7 at page 58. The plaint,
Yes. Plaintiff submitted.
Yes. About 4 or 5 lines from the top. The first defendant intends to construct a 3-story building in the Schedule B property. It is therefore clear the construction has affected the easementary rights of the plaintiff on a day-to-day basis. I'll just pause here for a moment.
Yes.
A building is being constructed, therefore, it is clear that it has affected the easementary rights. Construction is completely illegal and cannot be supported or countenanced in the eyes of law. The same is being contrary to law. The above facts and circumstances, having regard to the fact that officials of BBMP are hand in glove with the first defendant and the judgment, it is only this honorable court that can protect the rights of the plaintiff in relation to the free flow of air and sunlight. It is now well recognized that right to peaceful meaning and residence existence is clearly part of fundamental rights, that is right to life. In other words, law should come to the aid of the person whose very livelihood is being affected on severely on account of the illegal construction which is being impaired the easementary rights of the plaintiff. It is the case where the honorable court will have to intervene and uphold the majesty. The requirement is that habitation has become impossible. From where he was enjoying the rights, how easementary rights are applied. I am using this road. This is the road which he is blocking. Then he should plead that there existed a road or a passage in the first instance. How easement comes? This is my building. I have got 5 windows here. He is now closing the wall to an extent that whatever is the inflow of air and light through his windows is being affected. Therefore, my right of air and light is prevented. This is how easementary rights are filed.
In the other hand, it is very simple. Building plan has been sanctioned to see that it should not be affect to the air and light of the neighbor. Building, he says that building plan cannot be violated. That is the simple thing.
That's why I am submitting.
Otherwise, if you show that to giving a setback as per the plan is not for that purpose, then it is different.
Yes, I am submitting that so far as the setback is concerned, the object and purpose of a setback will certainly not be looked into in a civil court. It is not sitting there to look into the object as to why building bylaws are framed, what should happen. Certainly, these are not the objects for which the civil court is deciding. Nor your lordship sitting in an MFF will decide as to the interpretation of this policy. In an appropriate case, probably that will be decided, but that's not the issue. A coordinate bench of this honorable court has taken the view, relying upon the another view of a coordinate bench, which dealt with the very issue. that until and unless a substantial injury of free play of air and light is pleaded and the court is prima facie satisfied of its existence merely on the ground of violation of building bylaws, it is not for the civil court to grant an injunction. They have to go to the passport's office and seek for a passport. This is essentially what has been stated. Notes by the two coordinate benches of the circuit. This is essentially the case here. If your lordships were to see the findings recorded, the findings recorded on IA number 1 and 2 clearly says, IA number 1. So, if your lordships were to see, the court records a finding, it's a matter of trial.
If it is a matter of trial, then a tribal case is made of.
Yes.
If a tribal case is made of, then an injunction has to be granted. That is one of the parameters.
Kindly come to paragraph number 19 at page 44.
Yes.
Essentially indicating there is no prima facie case recorded, balance of convenience is not recorded. Paragraph number 19. As regards balance of convenience, certainly it leans in favor of the plaintiff rather than the present applicant because as already discussed, Supra, it has been specific grievance of the plaintiff IA number 1 due to offending construction put up by so and so. His right of easement to get natural air and light from beachfront properties adversely affected. Whether he has acquired such easement rights or not over the beachfront property is a matter of evidence. Yes. So that finding, once he records it, there is no injury which he has recorded for the purpose of granting an order of injunction. Therefore, my lords, by respectful submissions, that this order requires your lords.
Yes.
Grateful for the hearing.
Okay. The next counsel for the parties on IA serial number.
This my request, my lord, the main appeal itself, there is no more argument that either he will do or I will do and trouble your lordships further. Lordships may dispose of the appeal itself on merits.
Yes, Mr. Or on application. Now I have heard on application, I will say that permitted you to go on with that construction as per the plan.
Further construction in accordance with the plan, if your lordships were to say.
No, I will permitted you to go on construction.
Very well, lords. Your lordships can pass such orders and keep the appeal pending so that we will have one more round.
Yes.
Of submitting as to whether the suit should be maintained for solicitor purpose.
Yes. On IA, you will consider. Yes.
Very well, whatever.
Yes.
My submission is whether it is for IA or main matter, the arguments are said. Might as well the appeal be disposed of. Instead of keeping it alive is the.
Yes, he has some more arguments.
Very well, very
Yes.
well. Very well.
Yes. What is that?
Excuse me.
Yes, yes, yes.
Let-
Where is that IA? IA, is it? Why IA?
Office objection.
They have asked for a stay of my lord.
At page 97.
IA 1 of 2023.
Yes. Great.
Our learned counsel for. Is on IA 1 of 2023. Shri Ravi Shankar, learned senior counsel appearing for. Appellant has contended that the suit filed by plaintiff itself is not maintainable. If there is any violation of building bylaws, there is a statutory remedies provided under Municipal Corporation Act. The writ itself is not maintainable. He further contended that there is no specific pleading in the plaint regarding respect of its easement right in respect of air and light. He has relied on judgment of this court in 2001, 1 PLJ 468 has contended that no injunction can be granted on the ground that there is a violation of easement right of air and light. If there is any violation, his remedy is only before the competent authorities under statutory, under Municipal Corporation Act. The trial court, contrary to the provisions of the Act, has granted an injunction. He further contended that there is no finding of the trial court regarding whether the plaintiff has made out any prima facie case and balance of conveniences in his favor. Hence, he sought for stay of the order passed by trial court dated 9th January 2023. So and so learned counsel appearing for the respondent has contended that respondent has specifically pleaded in the plaint that due to that illegal construction, it will affect the rights of the plaintiff in respect of free flow of air and light. It is also specifically pleaded that they have violated the building bylaws and constructing the building. Contended that the judgment relied upon by the appellant in case of S. Sundarajan is not applicable to the facts of the case. Hence, he sought for dismissal of that. Hence, he sought for rejection of interim trial. How the learned counsel for the parties arose the impugn order. The suit is filed for. There is that claim.
Claim, Lord. You get at page number 54.
Declaration declaring plaintiff as an easement right of access and use of natural right and air to the suit scheduled A property. It is also pleaded that the building is constructing by violating that building plan issued by competent authority. The case which is relied upon by the plaintiff in Sundarajan case, the plaintiff has not made out any case to show that there is an obstructions of free flowing of air and light. Under the circumstances, the appellant defendant is permitted to construct the building in a rescheduled property. Now,
Yes. Rescheduled property.
rescheduled property in accordance with building plan.
Property. Hence, I have given the exact measurement in number page number 98.
Now, then you are happy that there is no injunction in respect of that property.
It remains is like our property is not properly described in the injunction.
No, now that I will say only in respect of suit scheduled property. Why do you take that? If it is not suit scheduled property, you can do it whatever you want. Yes, permitted to construct suit scheduled property as per the building plans issued by the
As per the building plan dated 7/7/2020.
even if you obtain modified also is entered as per the building plan issued by the competent authority. Until further orders.
Office objection to be overruled.
What is that office objection?
Office objection, my lord, there were two IACS challenge. He said on the last time that he will.
I will not press second IA number
Yes.
3.
IA number
I will not treat BBP as a party. Because I have not.
Office objection. The learned counsel for. Where is the two application has been filed?
Yes.
Which is that other application?
IA number 3 is filed.
Is challenged. Prayer earlier, current IA number 3. Subsequently, allowed.
No, now you are applying only IA number 1.
One IA number.
Yes, learned counsel for other auto schedule. Appellant submits that he will not press IA1 of IA3 of 2023. Submission is taken on record. IA is dismissed as not pressed. Since
IA3 before the trial court. The orders, he is restricting this present appeal. There are two orders, my lords, we kindly see.
in the prior itself,
The prior itself,
the prior of that. It is not
main ಅಲ್ಲಿ
yes.
IA number 1 challenge ಮಾಡಿದ್ದಾರೆ, IA number 3.
Our learned counsel for appellant has submitted that he will restrict this appeal only in respect of order passed by the trial court on IA number 1. Yes. And you take notice to that the BBMP. Why do you want to?
Any prayer against
Yes. He further submitted that he has not sought any relief against that. Dependent number 2. Submission is taken on record. Office objection is over.
Grateful.
Number 7.
Matter will come up for
Final disposal.
yes.
D. Lokesh.
Here for defendant's appeal, my lord.
Yes.
Office objection complied. Office serve ಮಾಡಕ್ ಹೋದಾಗ ಅವರು ಸಿಗ್ತೀನಿ ಅಂದ್ರೆ ಸಿಗಲಿಲ್ಲ ಮತ್ತೆ 1 week ನಾನು ಊರಲ್ಲಿ ಇರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಅದನ್ನ ಸಬ್ಮಿಷನ್ ಬರ್ದಾಕಿದ್ರು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಫಿಕ್ಸ್ ಮಾಡೋದು.
Yes.
ಅವ್ರಿಗೆ 3-4 ಸರಿ ಟ್ರೈ ಮಾಡಿದ್ವಿ.
ಯಾರಿಗೆ?
ಆಫೀಸ್ ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳಿದ್ರು. ಸಿಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
At the request, list this matter next week.
Next week date 14th.
Next 15. Yes.
15th ಬೇಡ. 14th or 16th. 16th my lord.
16.
ಆಯ್ತು.
Yes.
Number 8. Kalyan R for appellant.
Waiting service.
Yes. Awaiting service of notice. Interim order granted earlier is extended till next date of hearing.
Number 9. CM Srinivasa Rao for appellant. Anita KR.
I appear for the respondent in this case, my lord.
Yes. Non taking steps in respect of deceased or to. What do you want? Net counsel for the appellant prays 3 weeks time to take necessary steps in respect of deceased or to.
Number 10. K. Chandrasekhar Rata.
Appellant 2 weeks time to take steps. The second,
2 weeks time is granted.
not to show the name of Chandrasekhar Acharya. No more.
Office is directed to delete the name of K. Chandrasekhar Acharya for appellant. 2 weeks time is granted to do the needful. Connected matter, you have filed an wakalat in connected matter.
I filed a wakalat not put up.
Connected matter lo delete the name of so and so. Anil Shekhar KS has filed an wakalat. Office is directed to show his name for appellant.
Number 11. PM Siddhamalamba for appellant. We
2 weeks time is granted to do the needful.
Number 12. Niladu DK for appellant. Number 12.
Yes. Uniraju, weeks time is granted to comply the task of this.
Number 30. Vivek Goda for appellant.
Awaiting service of notice.
Number 14. Mandura D for appellant.
Compliance of the office objection, yes. Weeks time is granted to do the needful.
Number 15. Praise Kumar S. Parvati Nayak for appellant.
Lord, this is regarding the statement made memorandum of appeal.
Yes.
Let me just point your attention to page number 7 of the appeal memo.
Yes.
Here, my lord, I have stated that in second paragraph, appellant submits that he is the son of one late.
Acceptance of the statement stated at a brief facts of the case para with respect to the plaintiff number 2. Yes, what is that?
Please, my lord, let me just read out this one paragraph.
Yes.
The appellant submits that he is the son of one late Mr. V.T. Xavier, and
Yes.
he, along with his brother, Mr. Joseph Xavier, are plaintiffs 1 and 2. This is the plaintiff's appeal. I am plaintiff number 1. My lord, the
No,
plaintiff
what is
number-
that Major Thomas Javier you have made? Why
Lord,
that
the plaintiff-
second plaintiff has not been made as a party?
Please, my lord, second plaintiff died during the pendency of the suit.
He is died.
He is dead, my lord. I have
Who is
made a
that LR?
statement to that effect. I am the only LR, my lord. He has no issues. He is
Yes.
unmarried.
Learned counsel for the appellant has submitted that. That is the only office objection.
That is the only observation.
Submitted that. Second plaintiff has died during the pendency of the proceedings before the trial court.
Please, ma'am.
The first plaintiff is the only LR. Submission is taken on record. Office objection is overruled. Court yes, post this matter for admission.
Yes.
16, my lord, I appear
Yes.
for the appellant. I was the defendant, my lord, in the suit.
Yes.
The appeal has been admitted, my lord,
Yes.
on 25/3/22.
Yes.
Had
Why
we-
it is posted?
Yes, my lord, what happened was, my lord, at the stage, my lord, when we requested the court to take up the application for administrator, the court had then, my lord, felt that the matter lies in a short compass, could be disposed of. Therefore, a
Yes.
date was given. It has come up now, my lord, formally it has come up for hearing on IA. My lord,
Yes.
my request is, my lord, IA for administrator to be appointed. Here is
Yes.
a case, my lord, my case is that a trust has been hijacked by means of certain documentation.
Yes.
I was the founder of this trust. They have
Yes.
created one more trust with the same name. My request, my lord, if your lordships could accommodate us someday, my lord, at half an hour, my lord, time, if you lordships give me, my lord, that's all I will take for hearing. Paper books are ready and filed. The
No,
only-
that matter has to be heard finally now.
Yeah, my request is that my only reason is this, because administrator appointment will probably take the same amount of time or so.
Yes.
But there is no exigency to hear and
No,
expedite this matter.
no, that-
May make some.
Now wait, suit for?
Suit, my lord, was for a declaration
Hmm.
that there was a trustee there that was executed later that is illegal. That is the case that they make out. My
Yes,
case-
that has been dismissed.
Yes, my suit is dismissed.
Yes.
And the evidence, my lord, on record clearly shows. In fact, I'm fully ready, my lord. Last time it was supposed to be heard, but because of the change of roster, my lord, I think your lordships felt that the administrator application may be heard. My humble request, my lord, in fact, the other side opposed that and said.
Yes,
we
I'm
cannot-
opposing even now also for the simple reason. The suit
No,
was
they
already filed by my clients for a relief under section 92 of the CPC. It's a public charitable trust.
Yes.
To overcome. Another suit was filed in 2017 to get a immediate relief. And trial court went in detail, every aspect of the matter, found that what Malayan friends claimed is a fraud. And he has indulged in misappropriation, crores of rupees belong to the trust. That is how the suit came to be dismissed. What is the exigence? There is no such exigency. Let the matter be listed in usual court. But this is what they done.
The
When the
other
initial
side,
suit was dismissed,
the other
they
side,
expedited, they requested dishonorable court to dispose of the suit, and dishonorable court again reminded the matter. This is how they are playing this one with the courts also. There is no such an exigency.
Was this matter for hearing in first week of March?
please, my lord, grateful.
Number 17, is Kumar for appellant. Matter,
I appeal for the plaintiff in the appellate proceeding for in the cross appeal,
Yes.
that is the, you not kindly.
Cross appeal, who are the respondents?
First appeal is already admitted, Miller. The appeal bearing number, that is 719.
That you are appearing for whom, Mr. V.P. Shivkumar? What is your client's name? No, Allah. Plaintiff, all plaintiff.
In the cross appeal, I am appearing for the appellant.
No, that first let him take notice in cross appeal. Yes.
I may be permitted to file a memo. The FPDP proceedings are initiated and for having filed the after filing of this appeal. Now you will not make any stay the proceedings on 14th is the
No,
matter.
that you are appearing for. Plaintiff.
Matter 719.
Yes.
Notice. Because I take notice in the cross appeal.
That's what that, who are the,
To file objections to those.
no. First, let me see who are the respondents you are appearing in his case.
Savitramma represented by a legal representative. The defendant number 2.
Savitramma,
Defendant number 2.
defendant number 2, you are representing.
Dear my lord, the second respondent.
Wait.
Number 3.
Savitramma, Narayan Swamy,
Defendant
Rajan.
2G2D. G2D. But she was a defendant in the case.
No, you have that copy of that is appeal, man. Just give that.
3, 4 and 5 my lord.
3, 4 and 5.
3, 4 and 5.
Yes. V.V. Shivkumar is undertaken to appear for respondent number 3, 4 and 5. What about that others?
Sir, notice has to be.
Yes. What is that suit, Mr.
One for partition, my lord.
Hmm.
In the party that has been decreed,
Hmm.
questioning the correctness of the judgment and decree,
Hmm.
we are before this honorable court. You will not make failure.
No, he is also, you are also challenging that, this thing.
It's already it is, his appeal is 790 is admitted by before.
Yes. Now, who is appearing for the plaintiff now? Notice has to go.
No defect.
What is the stage now? Now the final
Now the
degree,
FTP is fine.
drawing of final degree proceedings will be stayed. Yes.
Till the next.
Let them not alter the nature of the properties. Who the plaintiffs, the
Question of partitioning.
No, now that partition suit, only final degree proceedings has to be stayed. And if there is any parties are alienating, you can move before the court, we can restrain them. Yes. Usually 17.1 only. P.V. Shivkumar is undertake to appear for so and so respondent. Issue notice to other respondents. Drawing of final degree proceedings is stayed till next date of hearing. In your case, proceed the service is completed, Mr.
no,
Yes, I would really week's time is granted to do the needful.
Number 18, Nataraj T for appellant.
Yes.
Say before the district court. So.
Learned officers, learned counsel for the appellant has filed a memo. You want to return that and represent?
Please.
Yes. Filed a memo seeking return of the file to represent the same before appropriate legal forum. The memo is taken on record. Office is directed to return that appeal memo and certified copies to that appellant to represent the same before appropriate legal forum. 2 weeks time is from is permitted to Office is directed to return the same forthwith. The appellant is permitted to represent the same before appropriate legal forum within 2 weeks from date of
Limitation.
Huh?
Limitation.
Within 2 weeks from date of receipt of that certified copies. Otherwise, you can't keep.
Question of limitation.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಲ್ರಿ ರಿಟರ್ನ್ ಆಗಿ 2 ವಾರದಲ್ಲಿ if you present then their limitation will not come. Yes.
Maybe say so.
That is what that Mr. Yes. Non-compliance of the topic of the. What are the topic subjects?
Certified copy. This is the Malad. Final degree proceeding.
Annexure marked to be removed from that index and entry of the appeal memo. Genealogical tree to be filed. Paper, other certified copies of the OS judgment degree valuation slip, other papers to be removed, filed separately. Counsel for the appellant to be accept wakalat. Certified copies of the judgment. Wakalat is not yet accepted. That is what the topic subject.
Except Malad, the certified copy of the OS. But
other objection is complied.
Compliant.
Regarding one non-compliant objection.
Needful has been done.
There. Apply ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೋಡಿ.
Only thing is Malad, this is a final degree proceeding, not preliminary.
Partially comply ಮಾಡಿ ಇನ್ನೂ ಎಷ್ಟು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ನಾವು.
Still is there said that it is pending.
Only in respect of production of the certified copy.
Office says
The production of certified copy. I am questioning here final degree proceeding, not preliminary degree proceeding.
that you said that it is accepted. Wakalat is not accepted. These are all the topic subjection is not compliant.
Now they are filed Malad, the execution, they deliver one to
No,
issue.
your wakalat itself is not accepted. Office subjection is not compliant, Mr. Even after granting the 4 times.
The question is Malad, I said, you will not say everything is compliant at the file. The statement Malad on 15/11/2022 Malad made a categorical statement Malad. Filing memo.
It is not mentioned in the wakalat executed in our presence in dash language known to him, that is not there. These are all not filled up, Mr.
They ask the delivery warrant while execution.
So, Mr. You have taken 4 times. If that would be the case, you could have complied and moved it. See, if it is everything is complied, I have no objection even taking at 2:30. The problem is that you are not complying that for.
I have filed memo.
See, genealogical tree to be filed. Where is that genealogy?
This is not the preliminary decree. The final decree, that is not required. They are not produced in the portal. I have stated, madam.
Where?
Para 6 no, plaintiff has not published the G3 in the honorable court below, hence it is not required for this.
Yeah, you are also that joint family member.
Yeah, sure.
And you know that genealogical tree, if court wants to see that, how that relationship, that is how that we are insisting.
This is the final decree, my lord. Preliminary decree is our MFA.
See, genealogical tree is asking, it is not a part of that. It is for the court for easy to identify the parties.
My lord, no case, final decree is accepted, my
Here
lord.
for other certified copies of the OS judgment, degree valuations, the other papers to be removed and filed separately. Counsel for the appellant to be accepted that wakalat.
I was signed the wakalat also.
Executed personal before me as yes, what is that this thing?
No, in the final decree proceeding, my lord. Final decree proceeding, my lord, the person is involved, my lord. I produce a FDP, my lord.
What is the suit for?
Suit for partition, my lord. In respect to house property.
Yes.
And fixed deposit. You are also kindly say, page 26 FTP filed.
Yes.
You are also kindly say.
No, that what has happened to the suit?
The suit decreed, my lord. I have challenged the RFA, my lord. In modified the share, my lord. Again, my appeal is dismissed, my lord. This is final decree proceedings, my lord.
No, appeal is dismissed.
Then
what is your grievance before that final degree proceeding?
Just a minute. You also kindly see the impugned order.
Now, final degree has been passed.
Yes, ma'am.
What is your grievance there? Final degree is in terms of that preliminary degree, is it not?
In modified manner, preliminary degree.
It is modified.
Modified. I can dispose of
with a direction to modify that. It is not in terms of that direction.
This court modified the share, and modification. Then they filed the FDP before filing, before deciding the appeal, they filed the FDP proceedings. There, the appointment the commissioner. They are not given any.
No, that FDP proceedings has been decided before order passed by this court in RFA.
At the same time, appointment commission filed before deciding the appeal. On the basis of that,
no, is it the FDP proceedings is contrary to that the partition given by that RFA?
No.
It is in terms of that. Then what is that?
Well, the thing is, Malad, appointment of court commission is there. Those serving copy to me, they appointed commission. In this fact concern, Malad, different facts are stated, Malad. You also can see. Just your worship.
Yes. Now, what is your apprehension?
No, they filed the execution, Malad. Execution without serving notice, without identifying the schedule, portion of the schedule property, house property. Yes. Deliver warrant is issued, Malad.
Yes, where is that execution petition?
The execution recently filed, Malad. I have not obtained the copy, Malad.
No, which is that number?
2765, Malad. 2765, 20.
Execution of final degree proceedings.
Yes,
the execution number?
2765, but 2020.
2765. 65 of
2022, Malad.
2022. Issue emergent notice.
They have filed.
They have further proceedings in execution number 2765 of 2022 till next date of hearing. In the meantime, appellant is permitted to apply that observation.
I appear for respond number 1 and 2, my lord, in this case.
Yes.
We need some time to bring LRs of deceased respondent 3.
Now that recalling that order, what is this, Mr.? which is,
My lord, it has been dismissed because LRs of RPO is actually not connected. It's a
on that
different
day,
property.
there are no representation on behalf of the applicant as already stated, though that matter is called twice. Appears. Order to be take notice steps in respect of the deceased respondent number 3. Yes, you have not filed any application.
My lord, for recalling the order, we have filed an IM.
Hmm.
But LRs, we require some time to ascertain because he's not connected to our property. It's a different property.
Yes, if get ready with that application, then we'll recall. The day you have recalled, you have to file an application in the counter. Otherwise, again, you will not do it. Then same thing will be happen. It is 2013 appeal, Mr. Yes. At the request of the appellant, leave this matter of 3 weeks.
Number 21, Pradeep Nayak came for appellate.
Okay,
Freedom for day. Last motion.
Yes. Yes, what is this? Mr.?
Here may be allowed.
Yes, what you say, Mr. Yeah, appeal copy is not served. You have any objection to the condonation of delay? Huh? Code, copy code next week. Yes. You serve a copy to Mr.
Number 22, cases one for appellant. Taj and Taj, Vishwanatha Shetty. Name Abbasi.
Amendment carried out, amendment appeal. Appellant number 1 died, my lord. Appellant number 2 is the successor of number 1. It's fine, amendment appeal.
For a permission to R1 to appear as in a party in persons, non-filing of the amended appeal. Yes, you have to file an amended appeal, Mr.
Yes, ma'am.
Yes, love. Yes, learned personal appellant.
Carried out.
No, that application is allowed.
Yes, my lord.
You have to file an amended.
I carried out amendment also.
Yes, finally, 2 weeks time is granted to. Yes.
It has been posted for final hearing.
No, that. Yes. No, appeal is admitted. Now matter has to be heard. It is 2021 matter. Yes.
My lord, he also confirmed this interim order.
Yes.
And the trial court has, this honorable court proceed for order, main suit. And only it has been posted for final hearing.
Yes. Next week you have to file an amended petition.
Yes, ma'am.
Then we'll post it for hearing.
Yes.
Yes, finally week's time is granted to apply the top subjects. Yes.
Number 23, Rajesh Bibad for appellant. Akash. Niti, Ramesh.
Yes. Yes, but vacating interim order. Yes, what is this?
This relative appeal is the rejection of the application to application filed for injunction not to put up of the properties
No, that suit for.
for declaration and for injunction. But this is between the family members only. Not the my request is may I request not the instead of going to the all this the actual aspect. Lakshmi kindly see the order passed by the learned trial judge.
Yes, we will come to that. First, let me end. Then that your application for temporary injunction.
Yes,
Yes, that has been dismissed.
yes. On the ground,
Now you are claiming a declaration on the basis of.
declaration based on the testamentary succession. Because the will was executed. Not I will explain to Lordship the question of this. But the
No, now that,
originally the
no,
property.
that I will come to that facts. Now that we want to that restraining that defendant from interfering.
Not only blood, he was putting up construction, change the nature of his blood, what happened?
No, admittedly, defendant is in the possession of the property.
No, blood, now the forcefully they have entered, but we filed a suit on in 2010.
Yes.
And on the ground, we acquired the title by way of testamentary section by execution of the will. So now after filing the suit, they appeared, filed statement and other, the subsequent, there were several other suits in respect to subsequent purchase, all these things are pending. In 2022, the all of a sudden, they are a little powerful person. They entered into the premises. They started putting up the warehouses. But 5 warehouses in simultaneously started. We filed an application for injunction. The trial court rejected this. Then we approached this honorable court. This honorable court has also directed them to maintain status quo, not to put up any construction.
Despite that, they have constructed another 3 warehouses. Their contention is, we are putting up agricultural farmhouse. In the 2 acres of land, can anyone believe that 5 warehouses will be constructed in agricultural land without taking permission from the competent authorities? That is my.
No, see, if they're in the possession,
Not the reversible possession.
no, if they let them do it in after taking a necessary permission from the competent authority without claiming any equity. If you succeed, then everything will go.
The suit is of the year 2010.
Yes.
And now the trial court may be directed to dispose of the suit at the earliest possible. Until then, let them not put up any warehouse.
No, see, suppose if you fails, if you suffer any loss, can you compensate that?
But contrary also.
Contrary also, if you succeed, if you want with that warehouse, you take it. Otherwise, they will remove it and give it vacant place.
The question is this: there are declarations for declaration and injunction.
No. Suppose if you succeed, you will not lose anything because you will get in a vacant site. If you want a farmhouse, you take in a farmhouse. We'll make that clear. Yes.
The question would be, definitely their contention, no, that so far they are not taken. Once I accept for this, concede for this,
yes,
their defense definitely will be put for declaration without seeking possession is not maintainable because in the High Court, the Honorable High Court, in an observation, suit has to be dismissed without seeking permission.
No, I will take on your contention that during the pendency, they have forcibly entered into the. No. See, he has right to take all this contention. Yes, I will also consider your contention that it is not forcibly taken. You are there in the earlier. Under these circumstances, I will direct that in view of that injunction application has been rejected, you are permitted to construct in accordance with law after taking all necessary, but it is made subject to that. You are not claiming any equity. Yes.
The person who has executed a living that paper has executed several days. Second question is, they are not changing the nature of the property. Yes, I by them. One is not to change the nature of this. Other is not to give the consent.
No, that is it your prayer that not to put up any construction?
Yes.
That means to say that they are in the possession.
Our contention is during the pendency in 2022, they forcibly entered the premises and not even illiterate. They are all very powerful persons. They are having a lot of properties.
No, but how can you file such an application along with that claim not to put up? That means to say
not in the claim. Suit is filed in the year 2010.
Yes. Have you taken that contention in that application that they are forcibly? Yes, that I will record. That I will record that is your contention. Then in view of that, let them continue but not claim any equity. Yes, what is your instruction, Mr. That is all different. Let that trial court decide. We are not coming that way.
This is a family member.
Is it not possible to any settlement?
Person without issue has given the properties to these two brothers, but two sisters married two brothers.
Yes.
One has married an outside person.
Yes.
And his son, the person was the lady has no issues.
Yes.
Therefore, she has the first son was another brother-in-law's son. And she has bequeathed the property in his favor because he was looking after her. These are all the things, intricacies was there. And
see, what is that other person's claim? Saying that there is no such will.
What they are saying is, initially there was a gift in the year 1954 itself. There are three sisters.
Yes.
And both of them are saying it is not a valid gift. And the Venkatam, that is the lady and others, they have sold the property. Now they have challenged that even the sale deed also. We have also challenged, they have also challenged.
Yes.
And that party is taking advantage of the dispute between the family members.
Why can't you? Otherwise, the third parties will go on taking that advantage. Why can't you settle that?
Also, of course, I have adjusted to my.
Yes.
Our- and
Subsequent. That is one thing. Then 18 and then another registered bill. Then 15 to 89 is his bill. Subsequent to that, there are 2 sale days. The person was executed, bill has executed a sale day. And our right is some portion for which there is a clear title for 1964 to this day. So this one, based on bill, they cannot maintain because.
Now, who is that original owner? What is her name?
I will explain to you. Today, original owner is one Mr. Marat, this is this. One Sannappa was the oppositor.
Yes.
He had one daughter,
Yes.
namely Muniyakkamma, and 2 sons. I just only last
You have the genealogy.
Yes.
Yes, yes.
Urology did not.
Yes, yes. Sonappa. Yes.
Sonnappa was the original propositor.
Mm.
Muniyakkamma and Chikkanna and Changalappa.
Yes.
These are 2 sons and 1 daughter.
Yes.
But the Muniyakkamma had 3 daughters,
Yes.
and 1 son.
Yes.
And 1 son died, leaving behind his wife Sonnamma.
Yes.
And this Muniyakkamma's daughter, Venkatamma,
Yes.
she married to Venkatamma. Venkatamma married to Changalappa. That is the second son of Sonnappa.
Changalappa.
Akkan Magan Madavarkanda.
Second son of
Sonnappa, the Changalappa is the first line.
Changalappa.
Changalappa married Venkatamma.
Yes.
And Marakka, second daughter,
Yes.
the another brother Chikkanna married.
Yes.
And this Chikkanna, this Munivenkatamma has another daughter called Muniyamma.
Yes.
Muniyamma's son is Anjanappa. That is the plaintiff.
Muniyamma.
Muniyamma, the
Muniyamma's son is that Anjanappa.
Anjanappa, that is the plaintiff.
Muniyamma has married to outsider.
Outsider. That is the problem. This
Yes.
Muniyamma married an outsider.
Yes.
And she got 1 son that is called Anjanappa and another daughter Lakshmamma.
Yes.
This the
Now that who has executed that will and gift?
No, but I like just one more minute. This Changalappa had no issues.
Yes.
And this Venkatamma is the daughter of Muniyakkamma. Here she had no issues.
Yes.
And therefore, this Anjanappa is the first son of Changalappa.
Yes.
That is Venkatamma. She was taken this because her sister's son.
Yes.
And she had 2 daughters. This Venkatamma had 2, Marakka, that is Chikkanna's wife.
Yes, yes.
Marakka has 2 daughters, namely Anjinamma and Bellamma.
Yes.
Now the Bellamma is the respondent.
Yes.
Anjanamma died, Bellamma is the respondent.
Yes.
Now, no, she is no more and her children are there. But this is the family tree.
Yes.
No, but what happened was on 18 to 19, the property.
Now that property is in his whose hand? Chikkanna.
A to D property, A to D schedule property.
No, it is in Chikkanna. Who has executed the gift? Chikkanna.
No. What happened was on 18 to 1964, Changalappa has executed the gift deed.
Yes.
In favor of Venkatamma, that is his wife.
His wife only.
His wife and Anjanamma and Bellamma, that is Changalappa's 2 daughters.
Yes, yes.
And wife and 2 daughters.
Yes.
And this the 2 daughters, first Anjanamma died, she has no issue.
Yes.
And now the remaining is only Bellamma.
Yes.
Now the Venkatamma.
Now that then how you will get that Anjanappa get that any gift deed from whom?
But no. Anjanappa, what happened was thereafter, this Changalappa and Venkatamma,
Yes.
both the Changalappa husband and wife,
Yes.
they have executed a registered will in favor of Bellamma.
Bellamma.
Yes. Bellamma alone.
Yes.
So this was executed on 18/4/1973.
Yes.
And after the death of Changalappa, the Venkatamma cancelled the registered will. on 14/10/1980.
Hmm.
And one cancellation amounts to her share only. Let us assume not 50/50.
Yes.
Her share is cancelled. She has the right in respect of her property. On 31/1988, this Venkatamma executed a registered will in favor of Anjanappa. That is the prime thing.
That is your claim.
Yes, no, it is a registered will. And what happened was, unfortunately, when we went to the trial court for declaration, claiming they are based on the will, original will was not, only certified copy they produced.
No, ultimately, you both are claiming, you are claiming that 50% of that property is
5 acres and we are concerned about 2 acres. The brothers, they are
defendant claiming that entire extent has been gifted in their favor, therefore their rights over the property.
then
Yes,
there is
that-
subsequent event is, after all these things, this Venkatamma and Maraka, that is these two sisters,
Yes,
has executed the sale deed in favor of one Chandra Reddy and Balu Reddy.
yes,
That is respect to entire extent.
yes,
Earlier 50/50, entire extent they have sold. These two persons, the Bellamma challenged the sale deed,
yes.
executed by her mother and aunt. That is pending consideration. There was a direction.
No, now that I am not deciding any that.
These are all the things, the intricacies are very much in this matter. And
No,
we
now
claim
that, as on today, admittedly, they are in the possession of the property.
the forcible possession.
Yes, yes, that is there. Then your grievance is there, they should not be put up any construction. Let them put up a construction in accordance with law without claiming any equity. Then I will also direct the trial court to
My
dispose.
contention is that in possession. If they say that
No, if you say that, don't put up. What is that meaning? You are not in the
now
possession.
I can definitely bring it to the notice of the trial court at the time of trial. The possession what they have taken is during the pendency.
That
of
is what
the
that,
court.
I will mention
And if
that
is the
your case is
then
that.
I need not ask for possession because I
Yes, yes, that will not be. See, your contention is that as on the date of the filing the suit, you are in the possession. Subsequently, they have taken the position. They are saying that they are claiming from the beginning. That is the dispute before the trial court. Now that the defendant is there in that possession, let him continue that construction in accordance with law without claiming any equity. Trial court decide without influencing any observation here.
And Marathi. Also, if required, the legal position I will also again explain. Even if possession is taken, because there is one judgment that even if possession is taken during the pendency of the suit, the formal request for possession has to be sought. Court fee is a different aspect, whether it has to be paid or not, it is ultimately court has to decide at the final stage. But that is one amendment. Anyway, I will look into that position.
Yes.
Even if required, the amendment also be permitted.
Before the trial court.
Yes.
That is there. Nobody is.
That observation they can do. Any application that can be considered.
Yes, yes.
As they said, was at an end. Originally, this is 5 acres.
Yes.
5 acres. Let us assume for the lady, they did not give anything, only for this service. That is chicken and Chandlappa. Both of them had 2.5 acres, 2.5 acres each. What happened was this Chandlappa did not have children. So he executes a registered at an undisputed point of time, 1864.
Yes.
In favor of life.
Yes.
And in favor of his brother's 2 children. So what happens is 33 will just go to 3 different people. So ideally Chandlappa will not have any right at all because he has given.
Yes.
Venkatama, that should not execute a will. Something stronger part.
Yes.
Another sister's son is over there, she had given it. That was assumed for a fact. Subsequent to that, they have sold it in favor of the person's already in Chikarity. Not only that Chandlappa's wife Venkatama, though she had right to
Yes.
she has also sold the right of my mother.
Yes. Yes.
Including that they have sold is what they have.
Yes.
How this subsequent
Yes. No, it is not in that IA.
I will adjust.
Yes, yes.
Where 18? It's 63. Remember, all these things are matter of.
Yes, yes. Yes. That's all.
He 17 will para 18 and 18. Here
I would like to stand back.
the last time I said is that during the pendency of the two defendants tried to interfere with the plaintiff for the reason, hence the plaintiff filed IA 4 and 5 on 23 seeking for temporary injunction. During the pendency of the two defendants, one encroached upon the Schedule A property and changing the nature of the two Schedule A property and started constructing the shed.
That's what. That's all. Yeah, all the respondents are served. Yes. Yes. We can. Yes.
There are workable.
Yes.
Is
No, that
Yeah,
some see ultimately only these two persons are entitled for that share. Either 50-50 or 60-40, somewhere that we can.
That's good. That made us start. She could also have sold it. That's also.
Yes, let us. Yes.
Mother also, his mother is also sold. She is a party to Bharat.
Yes.
Okay, they're all and they are taking advantage of our distributed there.
No, if that trial court held that both that gift deed is not valid, then what is that effect? Other ultimately, Amele, it is on under section 8. 8 to 8. Other ultimately, it has to go under the 8.
Yes.
Yes. Yes, yes, I will pass my arm. Yes. This appeal is filed under Order 43, Rule 1 or CPC, challenging order dated 11th October 2022, passed by 4th Additional Senior Civil Judge, Bangalore Rural District, on IA number 4 and 5, filed by plaintiff under section 39, 1 and 2. Plaintiff has filed a suit for
Page 22 declaration.
yes, declaration. Yes, declaring that alleged register sale deed dated document number so and so, page 22 alleged. Pursuant to that, summons, service of summons, defendant appear through their counsel and file their written statement. During the pendency of the suit, the plaintiff has filed this IA number 4 and 5 has contended that the defendant has forcefully entered into the suit scheduled property and tried to put up a construction. After considering that objections of the defendant, the trial court has dismissed the application filed by the plaintiff under Order 39, Rule 1 and 2, being agreed by the same, the plaintiff has filed this appeal. So and so learned senior counsel appearing for the plaintiff appellant has contended that the plaintiff has acquired this property by a registered gift deed. The will executed by Venkatamala.
Registered will
Dated
on 30/1/1988.
31/9/88 by one Venkatama. Since the respondents are trying to interfere into that suit scheduled property, the plaintiff has filed a suit for declaration. During the pendency of the suit, they tried to interfere into the suit scheduled property and forcibly they enter into the suit scheduled property and started a construction. Therefore, they have filed an application for injunction. The trial court, without considering that contention raised by the appellant, plaintiff as error in dismissing the application. So and so learned counsel appearing for senior counsel appearing for which respondent you are appearing, madam? One has contended that the first defendant has registered gift deed executed by Changlapana.
Second paragraph.
Yes, Changalappa on 18/2/1990.
Yes, Changlappa 18/2/1964. Registered gift deed has been executed by Changlappa in favor of the defendant number 1. And thereafter, 18/4/1973, the Venkatama has both Changlappa and his wife Venkatama has executed a registered will deed in favor of the defendant number 1. From 1964, they are in the possession of the property.
They have challenged this, but 18/2/1964 is the gift deed in
Yes.
favor of Venkatama. That is why his wife. Venkatama, Anjanamma, and Bellam.
Yes. Now that there is their claim. I am not giving any finding. Yes. From that.
And even that gift is also under challenge.
Yes. They are from 1964. That they are in the possession of the property. Now they have obtained necessary permission from the competent authority. They have.
Permission.
You will do it in. See, now that defendant will put up a construction in accordance with law.
Future constructions.
Yes. They are in the possession of the property and they have put up a construction in part of the suit scheduled property. Put up a construction for an agriculture purpose. Constructed a building for an agriculture purpose in part of the suit scheduled property. Therefore, trial court has rightly rejected the application filed by both the parties, filed by the plaintiff. Heard the learned counsel for the parties. What is the stage of the suit now? Yes. Now the suit.
The application on the ground, both the parties have produced several documents. Some of them are disputed, some of them are admitted. It will take long time, therefore I am not granting.
That's what I
It is
said.
not delayed, therefore I am
Trial
not
court
granting.
has, without considering your contention as error in, I have taken that in one line and yes. Yeah, heard the learned concept. The suit is filed for declaration. After service of summons, defendant has filed their written statements. On the basis of the pleadings of the parties, now issue has been framed. It is set down for evidence. Both the parties are claiming their right over the suit scheduled property on the basis of the gift deed and will deed. Since
And we are also taking and succession also.
yes,
And succession.
since both the parties are disputed regarding that execution of the will and gift deed under this circumstance, and that matter is pending before the trial court for final disposal. Under these circumstances, only relief can be granted back. The defendant, number one, may be permitted to put up further construction in the suit scheduled property in accordance with law without claiming any equity. It's all subject to the result of the suit. Accordingly, the appeal is disposed of. The order dated so and so passed by the trial court is modified to the effect that the defendant number one is permitted to put up further construction in the suit scheduled property in accordance with law without claiming any equity, and it is subject to the result of the suit. The trial court is directed to dispose of the suit without influencing any observation made by this court, and also parties are liberty to file any necessary application. Same may be considered in accordance with law.
Already I do warehouse ಕಟ್ಟಿದ್ದಾರೆ.
You want to do any further construction?
ಅಲ್ಲ ಇವ್ರು whatever they have completed this time, but further ಅಂದ್ರೆ ಮತ್ತೆ ಇನ್ನು 10 warehouse ಕೊಡ್ತಾರೆ. See, the defendant is permitted to complete the construction which is started. Permitted to complete that construction in the suit scheduled property. That is subject to the result of it. Yes. The parties are also liberty to file any necessary application. Trial court may be considered same in accordance with it. I don't think limitation can be fixed. If you see this controversy, it will not decide even 1 year. Then you will file an application for amendment. Then it will be challenged and all. Let it be there. Yes. Yes. Otherwise, pending this all MFS, I am saying that I try to dispose of. Otherwise, after 5 years, same result, unnecessary pending in the suit. All pending applications are disposed of. Yes.
For seeking unifying breach of contract in the defendant.
Yes.
As the respondents. I'm the argument holder.
Yes. Notice. Yes, charity. Notice. There is a delay. Let the notice. Yes.
I was directed to file a better appeal, but I filed a better.
You have filed it. Yes, notice.
Is delayed for injunction.
Yes.
File this appeal.
Notice.
Interim articles.
No. There is a delay, Mr.
51 days.
No, 1 day delay is also in a delay. You may take hand summons if you want. I will permit.
Respondent is the police constable. He is blackmailing the appellant, the widow.
This is not concerned. There is a delay. If you want to take hand summons, I will permit it. Or you emergency notice. Emergency notice. Yes.
Okay. Is settled.
Settled. Yes. Learned counsel for the appellant has filed an memo stating that The parties have settled that matter. Parties have settled the matter in that compromise petition, in that execution petition. A final in FDP proceedings. Hence, the appeal will not survive for consideration. The memo is taken on record. The appeal is dismissed, having become infectious. Pending applications are disposed of.
Number 28, MP for appellant, connected matter, Jairam.
Yes. Yes, what is this, Mr.? You are appearing for? Appellant. Now why it is posted? Act relating to the suit schedule property, furtherance of the revenue records. Suit for declaration. Now the appeal is admitted.
Regarding the stay, sought for, my lord, I read out the stay application. But it isn't stated in the accompanying affidavit, it is respectively made that this article could be reduced to restrain the respondent, their agents, doing any acts in the relations to the suit schedule property in furtherance of the revenue records. But under the order is mentioned. I'll read out the order. There should be no interim order. And furtherance in the, they are interfering with the agricultural order.
No, what is that the entry when that order has been passed?
29/2021. But it's they sought for order of stay. In
There
furtherance.
shall be an interim order restraining the respondent is the agent assigned from doing any act related to the suit scheduled property and furtherance of the revenue record in respect of the suit property. Yes.
And then in a difference for one, they should be in furtherance of they sought for stay in respect of in furtherance of the revenue records. But
Any act related to the suit. Order restraining the respondent agent assigning from doing any act related to the suit scheduled property.
So in under the advantage.
ಎಲ್ಲಿದೆ ಆ ತರ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ?
Application is number one. They sought for. Page number 34, my lord. In furtherance ಅಂತಾನೆ ಕೇಳಿದ್ರು. ಇಲ್ಲಿ ಅಂಡರ್ ಆಗಿರೋದ್ರಿಂದ they are taking advantage of that and extremely
34.
34.
ಎಲ್ಲ ಐತ್ರಿ application.
Petition 34. Appeal, main appeal.
Resident are pleased to respond to agent from doing any act with the suit scheduled property in furtherance of the revenue records in respect of. Yes, now you want to you filed an application for modification. No, vacating if you are seeking for a modification, that order file a modification because it has to go before the same judge. Yes.
Regarding the complaints I filed in this week, regarding the.
Yes, week's time is granted.
Yes. Matter, serial number 29, Ramachandra N for appellant, MS Ashwatha Reddy.
You file application first, then. Yes. Yes. Suit is disposed of. It become infectious. The net counsel for the appellant has submits that. The original suit itself has been disposed of. If the appeal become infectious, submission is taken on record. The appeal is dismissed, having become infectious. All pending applications are disposed.
Serial number 30, advance, serial number 31, Dinesh Kumar for appellant, Sita Nanaya M.
Yeah, you can file an application for as an.
Just I want.
Yes.
Regarding that, my lord, at,
As an objector,
please, my lord.
you can file an application under,
My lord, kindly, page number 44.
yes.
The suit is filed by the respondent hearing.
Yes.
Defendant's address was shown. In that address, I am residing.
Hmm.
The place sought by the plaintiff in the suit, that is respondent,
Hmm.
is not to alienate the suit scheduled property.
Hmm.
But the decree was granted not to interfere with the possession of the suit scheduled property. Actually, I am in
Is
I
an
am in
agent,
possession.
servant, anybody claiming through the under him, he hereby permanently restrained from interfering with the peaceful possession of enjoyment of the suit scheduled property.
Yes, ma'am.
They are sought for an
Actually-
injunction.
Yes, ma'am. I am in the position of that suit scheduled property, madam.
No, see, now you are not in a party to that.
That is my contention is that, madam.
That is what that under section order 21 rule 100, if persons who are there in the position, you can claim there that I am in the position, degree is wrong. That is what that remedy has been given, is it not?
But yes, madam. But till filing of that execution, they are day to day coming and threatening with this.
You file an application, by this time you could have filed it. Last occasion I said, if
They have not filed any execution.
then why do you worry?
But by simply coming in my premises and threatening my lords.
No execution has been filed.
Yes, madam. But the property, scheduled property is same. The address as shown in the cost title of this book is same, my lord. Only thing is the father name is not different. He served the service of someone to some other person and got the expert interview.
Yes, Mr.
Here you don't have any benefit, even though it is treated back. You won't get any benefit, mainly thing. Whether if I know any problem, I can approach the concerned authority to.
No, now that you have filed in a suit in respect of that, there he is in the position. You are claiming position on what basis?
Well, I am in a position as an Indian person. My father property through I have taken obtained the successful certificate through proper jurisdictional court.
Hmm.
And
Yes, he is the necessary party. You are not made them. Then I will. Application has been filed for leave.
I have this suit was decreed, madam. Thereafter, I filed a miscellaneous petition. Miscellaneous petition was dismissed, and that only a ground that
Why that miscellaneous petition is dismissed? No, that you are not a party in the suit.
Yes.
You are not a party in the suit. You can't file a miscellaneous petition. That order 9 rule 13 is an ex parte order. Person who is in a party. Now your remedy should be that either you have to challenge the degree. Now what is that you have to? You are challenging that IA.
Miscellaneous.
How can you? You have to challenge the degree. You have to file an application permission to prosecute and challenge the degree. Not that IA order is correct. What is wrong in that? Why it is dismissed that it is not maintainable?
Same name of
Ground
my father.
that not made out any petition to certify the impugnative. There is any relevant claim with the respondent hearing plainly.
Having knowledge about the entire proceedings.
Who?
Having knowledge entire the proceedings. He's
No,
just
he is
waiting
not-
for the orders, that's all.
He is not a party.
Not a party, but he
Yes.
received a notice on same address.
If person who is not in a party can file an application under order 9 rule 13. What is that law, mister?
But my last person name is same, my lord.
No.
What they have mentioned is father name is in the suit. Past title of the suit is father name is mentioned as Mariappa.
Father name is?
Mentioned as Mariappa.
No, Mariappa la. Sampangi Ramaju ante.
And I am claiming as my father name is Sampangi Ramaya.
Their suit is filed against that Mariappa. Tanya of Mariappa.
Suit scheduled property same, but in the address in the past title is same as suit scheduled property. I am in the position of the solution.
Then notice has been come to your house.
Notice is not served.
No, the notice has come to your house because address is there.
Signature is
in the summons it is not my signature. If at all I have taken the notice, I summons, I will appear and I will contest the matter.
Yes, now you can challenge the degree itself. Now that it is dismissed that you are aware of the proceedings. According to the respondent, he said that Muniappa trying to alienate the suit schedule copy showing the original suit judgment and degree passed restraining the Mr. Has this Srinivas is in the possession or some other Srinivas, according to you?
That is the position as just only the namesake they have some confusion. Whatever it is, even though if I take an order against Mariappa, so you will not need not to be worried. If you want
No. Property where he is in the possession, then it will be the problem. See, according to you, you have made in a party whether this Srinivas or some other Srinivas. Whom you have made in a party?
I gave son of Mariappa because I put it Mariappa as a.
Is there any Srinivas son of Mariappa?
Is there?
Where is that? Any documents you have produced? You have produced any document, mister? Have you produced any document that there is a name of Srinivas son of Mariappa? You produce that document. To get in a degree, you make some false name and obtain degree will not be permitted. If you produce that there is a Mariappa son of Srinivas who is residing this address, then it is. What is the document you have produced?
Someone says, sir, he is not arrested. And main condition.
Where is that summons is served? Records bandidya.
It is judgmental can clear and mention.
Summons is served.
Yes, not on.
Then
It is denied.
yes, then we'll recall it and permit it into.
Any time limit may be fine, minus I am ready.
Yes. Otherwise, you produce that Srinivas son of Mariappa is a different person who is residing. Then I will not entertain this appeal. Next week.
We taken the order against Mariappa son of.
There is no son of Mariappa. How can that service can be held? You should, no, when you have made that so and so as in a party, what is that documents you have produced that this address is there? Otherwise, making in some persons and see that it is served and obtain that degree, ex parte degree. Now, according to you, this Srinivas son of Sampangi Ramu is not interfering into the suit schedule property. Not interfering. Then you file an affidavit, then you will close that. Yes, I will record your submission and then I will dispose of. Now, suit is he has obtained that suit not in favor of that appellant before this court.
He also mentioned in the constitution has mentioned because address is different, son of is different. The judgment in judgment also to
No, that's in respect of the same property he is residing. That is the problem.
there is let him approach competent authority. Why you?
No, that what is the document to show that you are residing in this address?
I have produced the at document number, my last sir. Document number 7 and 8 and electricity bills and photographs and
then all that
regarding property I have taken from the bank. Loan is discharged by made by.
No, then we'll pass a status quo order in respect of that property where you are claiming. Let us see, we'll secure the records, issue notice.
Indirectly, he will get
Status quo I will grant. If you are in the possession, you maintain. Yes. Serial number is 31.
I'll file an affidavit in regarding that. Let me give 1 week.
Next week. Yes, then you will file it. Yes, next week. At the request of counsel for that parties affidavit you file, not file the advocate. Why you are landing in the place.
Number 32, Shrikant MP for appellant. Number 32.
Yes, Shrikant completely.
For appellant,
Yes.
The appellants have challenged the input order on higher number 1 and 4.
Yes.
The connection A.
Yes.
At page 14. The government trial judge lost the order of status quo.
Yes.
With respect to the social property. I have read the operative portion at page 22. IA 106 filed by 91 pertains to amendment of CPC against defendants are hereby partly allowed. It is ordered that parties are hereby
That suit for
sued for declaration and possession. Admittedly, with respect to the defendant's possession, the appellants are defendants.
declaration and possession.
Yes, ma'am. Appellants are the defendants before the trial court.
Yes.
Before with respect to defendant's possession.
What is that order passed on IA?
Orders on the operative portion at page 22.
Maintain status quo.
Maintain status quo. Here, my lord, the learned judge, the lordship may kindly turn to page 77.
Yes.
Read it. 77. On 22/4/22.
Yes.
C.N. Basura, that is my colleague, advocate for defendant number 123 file undertaking of private, filed on behalf of the defendant. Sri Basuraj Gunjal, advocate for the plaintiff, submitted that in view of affidavit filed by the defendant side, order to maintain status quo may be passed. Considering the undertaking of affidavit filed on behalf of the defendants number 1 to 3, following order is made. Any construction made by the defendants number 1 to 3 in the suit property is subject to outcome of the suit.
Yes.
The learned judge has passed this order on 22/4/2022, and according to the directions of the honorable court,
yes.
I have filed of undertaking of affidavit. Lordship may kindly turn to page 71. 71 annexure H1. Last fourth paragraph, I will read my letter.
Yes.
Page 20. I submit that myself and my family members are abide by the judgment and decree passed by Dismissal court, and since we have constructed residential house as well as commercial building in written statement property, our use for our use and occupation, and the said construction is subject to outcome of the judgment and decree passed by Dismissal court. When such an undertaking taken by the appellant's malad and the plaintiff's malad, the respondent, he has filed a suit only on the basis of one register sent in, he has not.
No, now that we are not deciding on the main matter.
Yes, madam. Yes, madam.
See, your undertaking is that any construction made by the defendant is subject to the outcome of the suit.
Yes, madam.
Now that status quo is same.
I am constructing the building. Now, I have demolished the existing building. There was a old AC roof state wall.
No, that you are under construction.
Construction.
No, that
I have obtained the sanction plan. I have
no, it is not completed.
not completed.
Just they are in the right state, maintain status.
So here's the thing. I am in possession, madam. They are taken action before the learned judge that I am in permissive possession. Possession has to be proved. Ownership has to be proved. I have obtained two register salary and all the suit property title deeds with respect to Kata, sanction plan, taxpayer receipt, everything stands in the name of the appellant.
Yes.
The plaintiff responded, he has filed a suit only on the basis of one register sale rate. He has not published any title rate. And in the plaint also I have furnished that he himself admitted that except sale rate, he is not having any document. And that too, madam, when I am in possession, I have demolished the property, he is kept silent. When he also led the evidence. When I have demolished it, I am digging the foundation. At that time, he files an application not to change the nature of the social property.
Now that earlier court has recorded that he may be permitted. No, he may be permitted to construction, not to claim any equity. Yes.
File number 15. Defendant on the contrary submitted that page number 21.
Yes. Para number? Yes.
The defendant on the contrary submitted that it is not within the knowledge of them while pursuing the application and submission made by both the parties. I feel that the suit is filed for possession and declaration of prime schedule property and the plaintiff is in the apprehension that the plaintiff scheduled property will be alienated by the defendant to the third party, their nature and the nature of the plaintiff scheduled property will be changed. The defendant counsel, on the contrary, submitted that they are in possession as admitted by the plaintiff, and the plaintiff is a stranger to the plaintiff's property. Also submitted that the plaintiff has produced the sale deed and has not produced any other document to prove his ownership, and also submitted that there is ambiguity in the plaintiff itself, and the plaintiff has taken double pleading against plaintiff. This is their content. Hence, I feel that the defendant are already in possession on dispute, and the dispute is with regard to the title and ownership of the property. Hence, I feel that both the parties should maintain status quo. Hence, I proceed to pass the following order. Now, the stage is they have removed the argument and they are not put up any construction. Suppose if they are allowed to put up construction, then they will plead equity. But they are
No. Subject to that.
no one submission. Yeah, affidavit may kindly be seen. Undertaking affidavit.
Yes.
At page number 71.
Yes.
This is what stranger, the para number 2 is strange. That's what they have stated, stranger. And then para number 3. I submit that I have got good case on merits. And when the above case was posted for further chief of PW1, the plaintiff has filed an application for order 39 rule 192, read with section 151 of CPC, for not to change the nature of the suitable property, for which memo for adoption of written statement as objection is filed. And after hearing my counsel arguments, this honorable court directed my counsel to file necessary affidavit on the ground that to ascertain the ownership dispute, detailed trial has to be conducted. For the said reason, since our possession is admitted by the plaintiff during the pendency of the above suit, if any construction done by us is subject to final judgment of this honorable court. I submit that myself and my family members are abide by the judgment and decree passed by the honorable court. And since we have to construct residential house as well as commercial building in the written statement property, that is very important for our use and occupation, and the said construction is subject to outcome of the judgment and decree passed by the honorable court. So this undertaking, what they have filed is the written statement schedule property, because there is a dispute with regard to the title as well as identity, because they are claiming the very same property. Suppose if they are allowed to put up construction, they will plead equity. And at the same
No, see, admittedly they are in the possession.
no, admittedly, because my contention in the written statement is that I have purchased this property in a physical document, and thereafter I allowed them to continue in possession. Now they are contending that they have got Khata and other documents in their name. Those are all bogus documents, and so they have no right over this property. And for that reason, I have filed a suit for declaration and also for possession. So suppose if the suit is decreed, then again there are all sorts of multiplicity of
No, see,
yes.
if with the case that you are disputing his possession, then it is different.
No, disputing.
No, if the possession is admitted,
No.
suppose if you
No, there is
unsuccessful in the
no,
suit,
that's what
now
permissive
can you
possession.
compensate by that? What is the loss you suffered?
My entire reading fee.
Vishwanath, otherwise, suppose if you succeed, either you can, he can't claim an equity,
That is
no
not
degree can be passed on that.
correct.
This
But
thing.
the thing is here in the case where I have sought for declaration and my entire reading fee, I have permitted to stay in
That is what,
structural property.
no, that is true.
Now they are setting up independent claim over this property that cannot be allowed. That is what they may pass on this judgment. Is not
No, ultimately, whether you have any made out in a case for granting the declaration and possession. That is the case, it has to be decided.
that is what the title issue is. in
Yes,
the
that is what the
court.
test.
That's what the court gives
Now
by
that possession, you have not disputed that as on today is in the possession.
That's
Yes.
correct, Lord, but
See, he can be permitted to go on with the construction in accordance with law without claiming any equity.
no, that is
In
what
case
we
if
are-
you succeed, now what harm will cause to
The
you?
thing is, suppose if they are allowed, because this thing is, because they are constructing the building. Because it's as of today, it's a vacant land. And now, this is the right time to prevent, because if they are interested, what is the
No, that's, no, two things. One, he himself has filing in a affidavit not claim. There is a court order. No, it will be the.
That order may kindly be seen.
Yes,
That
yes.
order may kindly be seen.
No, not. I am passing an order saying that we should not claim any equity.
Yes, no, that 1 second.
Yes. Because no harm will cause to you if he is permitted, because 20.
That is 22 code to
Page
number 77.
Yes.
N. Basavaraj, advocate for defendant 1 to 3, filed undertaking affidavit filed on behalf of the defendant. The Basavaraj Jindal, advocate for the plaintiff, submitted that review of affidavit filed by the defendant side, ordered to maintain status quo may be passed. That's what I have requested.
Yes.
Considering the undertaking affidavit on behalf of defendant 1 to 3, following is made. Any construction made by the defendant 1 to 3 in suitable property subject to outcome of the suit. There are two words for order. The matter was posted for orders on IA number 6. After hearing the argument, they have also argued. And now they cannot take shelter under this
See, what should have first, till deciding my application, you should not put up. Court first said that you construct.
So
Then I will
what-
decide
at
status.
their risk. At their risk.
That is what now also.
Now,
Now
that is
also
what
we are-
now, why is, but that is the reason, my lords, how they, after considering all the aspects, the court has come to the conclusion that the suit is one for declaration and both of them are claiming title over this property, not protect the title, may not protect the property. The court has passed
No,
an equitable order.
No, that when that
Maintaining
is, no,
status quo.
Vishwanath,
What is
if the,
there now?
if the suit is for declaration and injunction, then you could have said that yes, position is there. But if you say that suit for possession, when he is there in the possession.
The Lord
Yes,
may
sir.
kindly turn cooperative, that page number,
Yes.
53.
No, that, I think that is the reasonable order. Let him not claim equity. Otherwise, I have to admit and grant an interim order. Then again it is.
Just pass on one judgment, my lords, so that, because
Doesn't-
2021, the cases here, 2699.
Hmm.
With order 39, while directing a party to maintain status quo while granting temporary injunction power of the court, it is to be stated that if any party to the suit, either just before or after filing of the suit, does something hurriedly in order to change the nature of the property with an ulterior motive for defeating the interest of its opponent in the suit, the court can take note of it for granting an order of temporary injunction or directing the parties to make it not to balance the interest of litigation parties.
No, see, you see the facts of the case where you are seeking for an injunction, party has to try to change the nature to show the court that here you are admitted his position. That is the difference. No, therefore, merely because I am permitting, no, Vishwanath, merely permitting him, it is not that he is succeeded.
No, once again.
Balance of convenience.
That's what now the client presented before the court that suit is for declaration, and I have clearly stated in the client that in permissive possession,
Yes.
and I have disputed the title. The court gives a finding that both of them are claiming right in respect of the very same property. It is equitable to maintain status quo. That is what merely because I have sought for possession, because I seek consequential relief. When I have sought for
See,
declaration.
when both are claiming that position in respect of the property, disputing position, then status quo will be naturally will grant a status. Here you have admitted its permissive position.
That's what permissive position on the basis that I have allowed them to stay. That's what now.
That has to be decided by the
That
court.
is what not protect the title. The court has given equitable pass equitable
Yes,
order.
yes.
And one judgment is also there that
Yes. Yes, yes.
Position paid.
Now, what is that? Is there any interim order which is granted?
Even meantime.
Suppose if they are allowed to put up construction and if the status quo is vacated, virtually allowing the.
No, status quo order granted virtually nothing but by his unsuccessful civil court itself has granted.
Because that's a status quo maintained in respect of civil property.
Till
Yes.
demolition, Swami. Evidence, further evidence, they made an application.
Yes. No, that interim order, that ex parte, the interim order passed by the trial court.
Let us go,
No,
madam.
not on the IA, before it is passed, that will be continuing.
Day 1 or after my school. L9 100 again thought I will not L9. Well, the lordship
Alienate cannot be permitted.
I'll model. The lordship kindly just go 43, page 43.
Yes.
Ali, plain, how to plain. Document number.
No, that I am not deciding any. Yes.
43 nalli. After the death of Venkatama, the plaintiff mother, by name Venkatama, who is the mother of the plaintiff, he became the absolute owner of the stewardship property along with his family member as legal heirs. And with the mother of the plaintiff, nor the plaintiff have obtained kata in respect of the stewardship property. They are not having any document, piece of papers in
No,
their
you are claiming by
only sale deed. What is sale deed?
no one sale deed.
What is sale deed?
He is also claiming on sale deed.
I'm sure the sale deed.
So now.
Both are claiming on the registered sale deed. But then only thing is that his position you have been admitted as on
No,
today.
that's what I have permitted.
Yes, that's
the
no.
defendant
We are not saying that he is in the position pursuant to the sale deed.
That's what.
As on the date of the suit, he is in the position of
Already
the,
doing that.
he can construct, but not because tomorrow if the suit is dismissed, the loss which is caused, who will accept?
That's what.
Otherwise, if you see, if you succeed, we get back that construction, or if you want vacant, we will put it that condition. He has to
Even
be
I have
given.
to
Ultimately, you will not get any loss at all. That's what
I'll
the
get back.
yes, Kumar. It is matter tomorrow. Yes. Tuesday, yes. Yes, notice. Yes. Why respond? Oh, yes. No, is it necessary to take paper publication here? Like here again, you have to take in paper because it is dismissed. Yes. Office is directed to secure original records from the trial court. Yes. Barli, record bandali. Yes. Bharat, yes. Yes. Yes.
Page number 11 members. Line number 1, 530.
Suit for filed by plaintiff appeal. Suit for ejectment. Yes. Suit is the then you have filed an application. So what is that prayer? No. What is the prayer in that application? No, when suit for ejectment, how can you say that not to interfere?
It is in the art first, page number 11.
Yes.
Defend number 2 hearing, my lords, he is also claiming the ownership. Defend number 1, my lords, who is expected the rent agreement in favor of me.
No, you are a plaintiff.
I am the plaintiff and
You
tenant.
filed
Plaintiff tenant.
you are a tenant. But what is that suit for ejectment? Ejectment, how can you? You said that ejectment. You have filed a suit for injunction.
Yes, please.
Yes.
Plus, page number 11, my lords.
No, that who is your owner?
The defend number 1, respond number 1 hearing. Defend number 2, respond number 2 hearing also filed a suit against the defend number 1, respond number 1 hearing.
Grant an interim order temporary injunction restraining the defendant number 2 from any manner interfering with the peaceful possession of enjoyment. Yes, what is that order passed by the trial court?
Page number 11.
Yes.
It's not detailed order, my lord, so.
Yes.
Considering the WS and application, they pass the order.
Yes.
Plus 4,000 present, D2 present, D2 files, WS with objections, IA, please the copy of the documents filed for D2. Third, CBR for D2 submits the subject matter, already a subject matter in OS number so also, where interim order has been passed in favor of D2 as on 28/7/2020. Therefore, the present lease agreement dated 21/7/2022 is opposed to the fact with the plaintiff and orders in 59/58/2021, where the interim order is passed against the present defendant number 1 and also Devara, who has been inducted as tenant of the future property. Accordingly, on going through the certificate copy of order sheet in OS number also as on passing interim order in this case, that is 25.
Where is the interim order has been passed in favor of the DS as shown, so therefore the present lease agreement is opposed to the facts pleaded by the plaintiff order, wherein the interim order is passed against the present defendant number 1 and now there is an injunction order.
Against my owner, another person who was clear tenant to the premises, who is the Devara. Against Devara and another.
Now then how can we again injunction can be granted here? It will not be conflicting with the interest granted in that other suit.
That is what was interim order passed in that suit on 28.
7/22.
Yes,
Hmm.
but my lords, my owner, responsible only having my lords, who has executed the rent agreement.
No,
in favor of
see, that is not that. We were not on the concern. Defendant number 2 filed in a suit has obtained that injunction order.
number 1.
Yes.
One hearing.
Now, can we pass an injunction order for him to not interfere, where he has a benefit of that interim order?
He has the benefit of our rights, but
Now, whatever may be the reason, either you have to be impleaded there, you have to challenge. Otherwise, there cannot be one court says that not to interfere. Another court is not to interfere for them person who has an interim order.
Yes, I am not a party in the.
Therefore, you have to be implead.
Yes, I will in the lords, both matter may be clubbed together, my lords. That is also their loss. But my lords, earlier when he filed the suit, in document number 2, hearing my lords, he filed the suit against Devara, who was the earlier tenant in the premises, against the owner, number 1 and also respondent number 2. Plus
No, that is not the issue. In respect of the same property, there is-
I am in possession, my lords, as on the date of 21/7/2020.
I agree, that is not the issue. When there is already an order from that other court, unless that is modified, can it be granted again? How can that one court has granted an injunction in favor of the person, other court is granted, you should not interfere?
I was in possession on 21/7/2020.
No, I'm not on that point.
Yes, I understood, but my only submission, I was put in possession.
No, even if you have an 100% case, can that subsequently pass an order contrary to that earlier?
I'm making the submission. On 21/7/2022, I was put in possession. My owner is executed the lease agreement. in
No,
favor of-
that is not that, Mr. Rightly or wrongly, there is an injunction order granted before order passed by this court. That is what I am saying.
Yes,
That may be a wrong.
my
and then-
only submission is previous status quo order.
No, again, same thing. He cannot implement that order because here status quo has been passed. They are not
I
a
was in
part.
possession.
That is what that you have to file an application, implement and get it modified or whatever you want to do it. Yes.
And that direction,
Huh?
can be-
No, that, what is that direction? You want to implement that? That you can implement.
He may be here, because without hearing this, my contention, without hearing this application, are this passed.
Yes, we'll issue notice. Other side has to be heard before passing. Yes, issue notice.
Appearing for the appellant in this matter, my lords. My lords, the suit is for partition and separate possession. The suit filed by the appellant along with the two respondents, my lord, that is respondent number 3 and 4, and respondent number 4 and 5, seeking 1/3 share in the scheduled property, my lords. Subsequently, it came to the knowledge of the appellant that
So now that it is not admitted.
it is not admitted, my lords.
Yes. Or admit.
My lords, there is a short point of question. If your lordship may consider it. The question.
This is
Yes,
is
my
an
lords.
appeal.
Yes, appeal is challenging the order passed under Order 7 Rule 11, my lords. But the contention of the appellant is simple.
Rejection of the
my lords.
suit. Why
Yes,
it
my
is
lords.
rejected?
Yes, my lords, that is the point, my lords. My lords, so after filing the suit, the appellant who is also plaintiff in the suit came to know that some facts and grounds which he urged in the plaint itself, there needs to be some clarifications, my lords. Hence, he also filed some memo before the trial court seeking to withdraw the suit itself, my lords. Memo on 11/7/2017.
Avoid the repetition of the plaint allegation. Now, why it is dismissed?
My lords, it was dismissed on the ground that this subsequent cause of action was not mentioned in the suit of the plaintiff, my lords. But my lord, the point is that my lord, I have already filed the memo seeking to withdraw the suit and seeking permission to file a fresh suit, my lords. In that scenario, the trial court exercising its jurisdiction or power under Order 7 Rule 11, thereby dismissing the suit, that does not come for the question, my lords. So the trial court could have simply
dismissed that on that day there is no cause of action.
Yes, my lords.
Is it any bar for filing a fresh suit if there is any fresh cause of action?
Yes, my lord. That's why I had filed a memo seeking permission to file a fresh suit.
Now, Mr. Counsel.
Yes, my lord.
In spite of that rejection of the plaint.
Yes, my lord.
Is there any bar for you to file a fresh suit on the basis of the fresh cause of?
There is no bar, my lord. I do agree, completely agree, my lord. But the question is
why
that
do you want to quash this order, Mr.? If you have a right to file separate suit, this order will not come in your way. Then why do you challenging this?
But when the memo for withdrawal is already pending. Yes, my lord.
I'm asking this question of law.
Yes. There is nothing to bar me, my lord. That is nothing to bar me to
file. Then what is the necessity for this to quash then? If it will not come in your way to file in a suit, that is what you want to do it. You do it.
Yes, my lords. If I may submit, my lords, senior might argue on the subsequent arguments. Lordship, kindly have it next week, my lords. I will submit my arguments with respect to the question your lordship has produced. Question your lordship has put up.
Yes.
Much obliged.
Request of counsel for the appellant. Is this matter next week?
Much obliged.
Yes, Shekhar Shetty.
Yes.
Parties ready for the settlement. Kindly around 2 weeks.
At the request of counsel for the appellant. This is matter of 2 weeks. Yes. Yes.
ಅಂತ ಹೇಳಿ ಆದ್ರೆ ಒಂದು ವಿಷಯ ತಮ್ಮ ತಿಳಿಸ್ಬೇಕು ಅಷ್ಟೇ. ಡೋಂಟ್ ಗೆಟ್ ಮೀ ನೌ.
Yes.
ಇದರಲ್ಲಿ ಅವ್ರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ ಬಂದಿದ್ರು ಅವರೇನೆ. That application filed by the respondent, the plaintiff, the trial court. They had filed an application as early as December 2022. That application is already on record. Their application to bring themselves on record was already present on the record of this honorable court. And here they are. I don't know how it missed.
What is that? I didn't understand.
ನಾವು ಇದೆಲ್ಲ ಆರ್ಡರ್ against ಡೆಡ್ ಪರ್ಸನ್ ಅಂತ ರಿಕಾಲ್ ಮಾಡ್ಬಿಟ್ರಿ ಫಾರ್ ಬೀಂಗ್ ಸ್ಪೋಕನ್ ಟು ಅಂತ ಹೋದ ವಾರ ಹಾಕೊಂಡು ನಾನು ಏನಂತ ತಾವು ಹೇಳಿದ್ದು
ಅವತ್ತು ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ನೂ ಅಲೋ ಆಗಿರ್ಲಿಲ್ಲ.
ಅದೇ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ತಮ್ಗೆ ಅದೇ ಹೇಳಿದ್ದು. What I submitted before this honorable court on the other day was that the advocate for the plaintiff respondent was also present. The lady was also present on that day. Your lordship passed an order. I don't know how that has got left to be missed out on the being noted. But that,
No. They have also no objection. When we were signing that, we are notified without bringing them on records. We can't pass an order. Otherwise, it is against the dead person.
I agree.
That is why that they have not moved. It is court itself has taken it as a being spoken.
For a moment, I am not in any. Lordship is correct. The lordship technically.
Now that application has to be allowed,
yes,
then we will consider for that status quo order, whatever the earlier order.
What has happened is, because the matter arises out like this. A property was sold.
No. We will come to that. This thing.
Property was sold by two different GPAs. Mine earlier in time, and the defendant plaintiff in this suit later in time. He files a suit for injunction, which is decree. which is I am before your lordship. My suit for declaration injunction has been dismissed in OS in RFA 568 of 2021 by waiting. There the lordship was noted that the presence of the other side was there. The lordship has passed an order of status quo there also. So your lordship may consider allowing this application. Permit me to amend. And same order of status quo may be
That is what that I said.
very well.
See, that has to be passed, only application has to be allowed.
Yes.
On that day it is not allowed because application, there is an objection, it is shown that there
Yes,
is an
yes.
objection. Now that there is no objection.
Yes.
Yeah, no, what is that objection?
I don't want application actually.
To bring, huh?
9th of January.
You to
I
bring
want
the-
the first application.
Bring LRs of
Yes,
that.
yes.
Then that application will allow, that is the proper. Which is your IA?
Mine is IA number 1. IA number 1 and 2 of 2022. I filed on 9th of January. 23, I'm so sorry.
23,
23,
that is not posted.
9th of January. Hackney.
ಅದು ಬಂದಿಲ್ಲ ಸರ್ ಅವರ ಇತ್ತು ಅವರ ಅಪ್ಲಿಕೇಶನ್ ಅದ್ರ ಮೇಲೆ
No, 230, get that IA. IA is not the record, you will get at 230.
Very well.
Yes.
Right. For the applicant.
Yes.
First plaintiff is-
Reference in the plaintiff shares as stated in the judgment to that of the degree of his objection. Yes, what is this, Mr.?
Last occasion will have initially to file suit was filed by 2 plaintiffs, that is the first plaintiff is the appellant herein and
Now that admission of his objection is overruled.
please.
What is that?
The suit is one for partition and separate version,
Hmm.
Trial court has partly decreed the suit so far as in item numbers decreeing the suit in favor of the plaintiffs C, D, and E is concerned. 1/6 share has been granted,
Yes.
Declined to grant in respect of A, B, F, and G of social properties are concerned, admittedly, schedule G property belongs to the brother of the first defendant, It was come in the partition, He died intestate,
Yes.
The contention of the defendant is that orally the property has fallen to the share of the first defendant is concerned.
Yes.
So, trial court has declared to give share in that item number G also concerned, So far as annexure item number B is concerned, Defendant 1 was AB employee, lineman, He has retired way back in 1978. The suit property was purchased in the year 2000, After purchase, the contribution from the joint family members, Though we have specifically contended before the trial court that, all the social properties purchased by defendant 1, with the contribution of the joint family members of the.
Yes, now that you take notice, yes, who are that other respondents? You will issue notice. Yes, issue emergent notice. Yes. You are appearing for which respondent, Mr.?
All the respondents there.
Except one.
You are not appearing whom?
Respondent number 5.
Respondent number 5, plaintiff number 2.
Please.
Yes. Aviator is undertaken to appear for respondent number 1 to 4. Issue emergent notice to respondent number 5.
They are purpose and in view of this, they have has been already changed in the favor of respect of the denying of the schedule is concerned,
No, Kata cannot.
Is already changed in the pendency of the suit.
Yeah, it is a partition suit.
Partition.
Yes, drawing of final degree proceedings is
They
stayed.
have not filed any appeal proceedings, they are trying to alienate the property. I have filed IA 2 AS, one is staying of the judgment also, and also 1 and 2 not to alienate the suit property.
Not
Pendency and not proceedings.
They have to find it. They have.
We are the agreed by the judgment. That's why we are filing the appeal.
Now that are you going to alienate that property?
Insofar as the schedule A, B, and F, whatever it is a self-report of the test, that may be, I have to ask him, like, no.
Let there be order of the.
No, which are the properties you are claiming?
A, B, and F and G,
A, B,
F and G.
A, B, and F and G. I will say that not to alienate, that parties are directed to not to create third party. Yes.
Please.
So notice, the parties are directed not to create any third party interest in respect of A,
B,
A, B, A, B, F and G of the appeal scheduled properties.
Please,
Till next date of hearing.
please.
Yes.
Number 40 action, seal number 41, for a decay for appellate.
Yes.
Partition. With dependent.
Good for partition.
Partition.
Hmm.
The being agreed. To me.
You are a purchaser. Yes.
What has happened is 2011, the city that very different. Different number one got this title by a property which was registered in his name by his father
Hmm.
in 19.
Hmm.
65 deed is not present. Different number 3 to 5 are the other children of the one's father. That's
Yes.
why different number 1 and 2 are the brother and sister.
Yes.
3 to 5 are the children of the second wife. Now there are also properties on which was purchased by my father.
Yes.
That is a different number one's father. It is not being brought into the partition. Partition was filed with the road.
Yes.
Suit has been declared before bringing the other part property. So one issue is whether that such kind of suit is maintainable. The question has not been gone into very time. So I have seen the first subsequent purchaser from the different number one who had the property in his name itself. The trial court has given a finding that this belongs to a joint family property, hence the saving is being registered in my name is being found. Violating the property then from the purchase of the property.
Now maintain status quo. Yes.
Or maybe say because they may parent.
No. Let us see that if they filed an execution also, they can't dispose issue because there is an yes. Yes. Issue notice. Parties are directed to maintain status quo in respect of suit scheduled property, which is that property which you have purchased, not all suit scheduled
Only
property.
one property is the property.
That is the only property.
Please. One schedule between 20, 40, 30 side. It's
Only-
higher.
That is the only site is the partition.
The other properties are also there. They are not brought.
Yes, parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing.
Good.
2:30. Yes, Mr.
Unclaimed ಅಂತ 10, 11, 12 ತೋರಿಸಿದ್ರು. 10 ಗೆ ವಿತೌಟ್ ಪೋಸ್ಟಲ್ ಚರ ಬಂದಿದೆ. 11 ಗೆ ನಾಟ್ ಕ್ಲೈಮ್, 12 ಗೆ ಅನ್ಕ್ಲೈಮ್ ಅಂತ.
ಮತ್ತೆ ಯಾಕೆ ಬರುದ್ರು ಅಂತ ಅನ್ಕ್ಲೈಮ್ ಎಲ್ಲಿ ಅವ್ರ ಪಾಸ್ an order how can that? Yes, we'll pass an order that only which is unclaimed, others you have to take steps. Yes. ಯಾವ್ದಾದ್ರು
R10 ವಿತೌಟ್ ಪೋಸ್ಟಲ್ ಚರ ಬಂದಿದೆ ಸರ್.
ಅದಕ್ಕೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡು
R11 ನಾಟ್ ಕ್ಲೈಮ್ ಅಂತ ಬಂದಿದೆ. ಆಮೇಲೆ R12 ಅನ್ಕ್ಲೈಮ್. ನಾಟ್ ಕ್ಲೈಮ್ಡ್ R11.
Yes, notice issued to that respondent number 11 and 12 is written with postal chara,
Not claimed and
not claimed.
unclaimed.
In service of notice to 11 and 2 is held sufficient. 11 and 12. Yes. Week's time is granted to pay the process issue notice to other respondents.
ಇದು ಎಲ್ಲೋ ಬೇರೆ ಯಾವುದೋ ಅವಾಗ ನನ್ನ ಪಾಸ್ವರ್ಡ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಕೊಟ್ಟೆ ಏನು ಅವ್ನು ವರ್ಕ್ ಆಯ್ತಾ ಇರಲಿಲ್ಲ. ನಾವು ಮಾಡಿದ ಯಾರು ಮಾಡಿದ್ರು ಮತ್ತೆ ಅದನ್ನ ಲಿಸ್ಟ್ ಇಂದ ವಿತ್ಡ್ರಾ ಮಾಡಿ ಅಂತ ಕೇಳು. ಯಾರು ಮಾಡಿದ್ರು ಅಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವಾಗ ನೀನು ಇರ್ಬಾರ್ದು. ನನ್ನ ಹೆಸರು ತೋರಿಸ್ತು ಅಂತೆ ಅವನೇ ಅಂತ ನಾನು ಸೆಂಟರ್ನೇ ಕೇಳಿದ್ರು. ಮಾಡ್ಸಿಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಏನೇನು
which is already
Yes, Mr.
And for interpolation, because of this reason, madam, I filed a suit for change of name. This change of name. The Sunidhi, surname is Adiga. Adiga was not there in the name. That is the reason for limited extent I filed a suit for the change of name. And the suit is dismissed only on the basis of limitation. Immediately after majority, I have to file a suit on that basis. Dismissal. It's a continuation of the cause of action.
No, what is the urgency for?
Urgency because of this is she pursuing the MBA for further course in the US. She already deposited the entire fee. Once it's a deposit and she selected as only one member in the Karnataka. And if the surname is not there, and it shows that surname not known, they mentioned like that. If it is not correct in all documents, they will not allow me to pursue the degree. This month, by this month end, I have to rectify all.
No, but it's true. Even if I entertain your this thing, again, matter suit has to be tried. This court cannot do it even by granting an interim order. How that any other who is your no, that even then, if you make out in a case, I can pay that degree, but you will not get any benefit. Who is your opponent?
All are expert. All are expert. State
yes, tomorrow. Sir. Not 2:30. Tomorrow.
Why that I will take it as tomorrow.
Not
once I will convince my
not tomorrow only. Today I don't know that who is the other side and I'll also take notice.
Central government is not a better person because central government not necessarily birth and death is concerned. Central government. ICC board also, my lord. ICC board also.
You get it assist tomorrow. Yes, tomorrow. 49. You are appearing for the request of counsel for the appellant. Use this matter of 2 weeks.
Matter, one, serial number 5, money and KBS for appellant.
Apologies this morning.
See, counsel wants to maintain that trust with that court because I have seen you when you are an advocate, you are practicing. See, I have seen that some of the matters you are argued when I am a government advocate, I think in some matters are something registration or some matters. I think I've seen that your arguments and all. When court has a trust on that advocate, it has to be maintained. We should not be act as in a party.
Absolutely.
I've seen that your arguments. See, that is how that advocates has to be built up with that court. Forget about that parties and all.
This case,
see, when I am on the other side in that government advocate, I have seen your arguments that when you are arguing that, I think it is in a registration matter or some matters you are arguing that. Now that Arun, only your grievance is that they are using this order in obstructing in that other meeting and all. That will clarify.
That's all. I'm ready with that.
Wait. Is there any other problem that?
Yes,
That is,
I will convince them. That day it was suppressed.
no,
Even
all
this
that
order,
suppress, it is all merit will consider. Immediately, what is your what that you have moved that memo and state that using this and they are obstructing in other meetings also. We'll clarify
Please,
if that is the case.
I will bow down.
Otherwise, if there is no other urgency, it will affect your rights in the
Absolutely.
interim order.
I don't want nothing else.
This applies only to.
That meeting you have taken on the.
Precipitate the product. I just
No,
explained.
let them file for modification.
Wait,
I will take only 5 times.
His retirement tomorrow is not an issue.
Yes.
Then he can file an application for modification.
62.
Let us see that. I have to hear other side.
Please.
And I have to-
Will not take much time. My last, may kindly see the plain at page 50.
No, that's on merit.
In 5 minutes, I got.
Yes.
Again, what will be consequences of the card? The
Yeah.
Honorable Supreme Court permitting for elections. The Lordship may kindly see, they are agreed for that 70 years. Our agreed agreed, I am not coming in the way. Kindly see, madam. Kindly see the prayer at page 61. That's
Yeah.
right. Before that, in so far as first respondent is concerned, now page 50, one day want to explain what it comes.
Yes.
This matters. Matters Church of South India.
Yes.
Church of South India is in Chennai.
Yes.
It is a body, unregistered body, which has its own constitution, comprising of Tamil Nadu, Kerala, Karnataka, Andhra Pradesh, Telangana, and Jaffna and Sri Lanka. Now it has 24 dioceses. One diocese is Karnataka Central Diocese.
Yes.
Church of South India proposed an amendment in February 2022. That was passed on February 2022. That amendment had to be ratified by all the 24 dioceses, 2/3 of the dioceses.
Yes.
That came up for ratification after 9 months before this diocese. There was a meeting scheduled for this.
No, when that meeting has been held?
Yes.
When?
It was held on 21/12/2022 before the trial court passed orders.
21/12.
2022. Admitted fact.
Yes.
Before the trial court passed. Ratification meeting. Earlier meeting is not under challenge. 7-2, the main body had passed the resolution that amendments have to come into effect, including 70 years, is not under challenge.
When that meeting.
7-2,
No, when we have amended that, what is that? It is a constitution or a rule?
Constitution amendment.
Yes. What is that?
One amendment is regarding the age which they are agreed.
Yes.
And our bishop will get benefit of that. The bishop in Karnataka Central Diocese will get benefit of that. He is going to retire on day after tomorrow. He has got benefit of that because of the amendment being passed. Admitted fact. That
Yes.
was
No.
approved on 7/2/2022. I'll correct the date.
7/2/22.
2022. That is not under challenge. Means ratification conduct they challenged. That ratification was scheduled on 12/9/2022.
12/9.
2022. Ratification.
Yes.
Your Lordship may kindly see the cost table. I'm sorry, I have explained to the cost table.
Yes.
Your ratification by third respondent, one of the 24 dioceses at page 50. In the plain.
Yes.
Page 50, plain starts at page 50.
Yes.
First defendant is the main body in Chennai.
Yes.
Second defendant is its head, moderator.
Yes.
Third defendant is the body in Bangalore. Either the election, ivaga meeting to that is under question before the civil court. Third defendant called for a meeting on 12/9/2022 for
Yes.
ratifying.
Yes.
That is under challenge. Your Lordship may kindly see the prayer
Yes.
at page 61.
Yes.
Declare that the proposed amendment as per the circular dated 18/8/2002, 20 of the first amendment to amend the constitution of the Church of South India in terms of class 12A of chapter 5, whereby the retirement age of bishop is sought to be extended from the age of 67 to the age of 70 is being modified not in good faith and consequently null and void.
Yes.
Lordship may kindly turn to the alternate prayer at page 62.
Yes.
In the alternate prayer, C.
Yes.
In the alternative to prayer A and B, and even the court is not inclined to grant prayers A and B, this on report will use to direct that any process of ratification of the proposed amendment to the constitution of the Church of South India in terms of class 12A of chapter 3, whereby the retirement age of bishop is sought to be extended from the age of 67 to the age of 78 after expiry of the 66 years, 6 months. Amendment iವಾಗ ಬೇಡ 6 months ಅಂದ್ರೆ ತಗೊಂಬನ್ನಿ ಅದನ್ನ ಅಂತ because they wanted to avoid our bishop to get the benefit of that.
Yes.
So ಇದನ್ನ court has said, trial court has said it's a modified exercise of this one.
My appeal.
No, I will argue only on the extension. Why is it filing shy?
You make a submission when you court has called you. Wait, let him explain that whatever he wants. Yes.
They have no objection.
Actually, my lord, due respect, not being subject to, my lord is right, and whatever my lord is in charge of the court. My understanding is an appeal proceeds with the, I have suffered an audit My lord will hear me. One minute, sir. You, my lord, ideally will not hear a successful party against an order.
No. Why
My
that?
lord will hear me first. And
No,
then
I will hear you. Morning you said that he has to answer why that interim order cannot be extended.
Yes,
Therefore, I-
assembled at 2:30, my lord, the judge will say,
No, I thought
he
that
will
I
not
need.
hear the matter or merits, what I could gather from the court. He's going on merits. He's going on merits, therefore I intervene.
No,
If
that,
it's going on merits, I've been permitted to start.
No,
Because
no,
he's going
not
deep
on
into merits.
I am not hearing the case on the merit.
Then I don't understand this exercise of
Yes.
trying to fix the mind of the court.
Yes.
What is the earthly purpose of my friend going through the order and my plate and other things?
Yes, you take your seat.
I will not argue more.
Yes.
They are not averse to that amendment. They say that amendment can come after 6 months. That trial court says modified. That is suppressed before this court.
Yes.
My lords, what happened in the trial court? When we see the order sheet, trial court initially, matter you page 38, I can see. Order sheet dated 9/9/2022.
That is Mr. Arun. See, that is not fair. See, when the court has granted an interim order till next date of hearing, it is, I think, January 2023. Before that matter has been preformed, then said that there is no extension of interim order. This is nothing but overreaching the.
No, I will demonstrate that trial court has held that.
Trial court has ultimately we have to.
Trial court Allah.
Advocate has to assist the parties.
I will demonstrate why it was done.
Demonstrate.
Wait, mister. Wait, I am asking.
I
that.
will demonstrate.
My lord, give me a complete opportunity.
Yeah, I will give that weight that I've seen.
Sorry.
I've seen that
Sorry.
there is an order to January, but when it is preponed, then yeah, I think that has to be based by that contempt court.
I will just.
I shied away from naming my party. Out of my protect. Out of my friend in the bar, he was not named in the contempt because I will demonstrate that the entire exercise
No, that will.
evidently was honest instructions.
No, that will be
That
there.
will demonstrate.
That
The
will be
vote is not the client. Also the court.
Whether there was an order on that day.
No, that is
overreach.
not overreaching. And technically, you are right.
No, not on technically, otherwise also, I will just demonstrate.
Yes.
Not make any see the order.
Yes.
Overreaching, I'll just demonstrate. There is no order on that day. Kindly see page 39, the operative portion of the order.
Yes.
Here number 259 of rating is here, we allowed. Our here Madhila matter.
Yes.
Because the meeting was scheduled, trial court said, third defendant is here to illustrate. From conducting a special meeting of the Diocesan Council on 12/9/2022 till 1 week.
Yes.
My lords, this application, if an order is passed on that, MFA should be based on that. It is not based on that, I just demonstrate to the court.
Yes.
If there was a overreaching, if the forum was there. they were not aware of
I am not
Yes.
saying that. I will not make any observation regarding
Yes.
that. That is for the contempt court to see.
ಅಲ್ಲ, ಇದರಲ್ಲಿ
Ultimately-
this MFA is maintainable or not?
Ultimately, institution has to be protected by the
Absolutely.
advocates.
Integrity of the institution has to be
Yes,
maintained.
it is.
I am there for that.
My lawyer assaulted.
What is
Assaulted. Gone to the
Wait, mister, wait.
Mr. Lawyer instruction was done.
No, that I don't know whose instruction and all, that is. No, you make it in that
My
contempt,
learned
not
will
in.
go into that, not the print.
We have
I have
an
not the print.
No, mister, See, you are all-
That I.
you are all practicing from contempt.
ನಾನು ಅದಕ್ಕೆ ಸುಮ್ಮನೆ
it's logical and malicious.
Yes, yes. Yes. Page 40 may kindly be seen. Extension ಏನಾಯ್ತು? ಕೆಳಗಡೆ. MPS advocate next day. MPS advocate present in front application to extend the interim order granted earlier. Hence interim order granted earlier will be extended till the next day. Previous date extend ಆಗಿರಲಿಲ್ಲ. I didn't object. Next day, previous day you are considering NDC extend ಆಗಿರಲಿಲ್ಲ. ಮೇಲ್ಗಡೆ. I just didn't object. It was extended by an application. Now kindly see the next date at page 41. Again.
Yes.
SM MPS applicant for plaintiff present the files application to extend interim order granted earlier. Hence interim order is extended till the my lords may kindly note the order till next date. Kindly note the order.
Yes.
So and so. Then it is posted to page 42, column 4 to 2023.
Yes.
I am conscious of that now.
Yes.
Column 4 to 2023. In the meanwhile, what happened? Your Russian is able to take the memo filed by us today.
Yes.
The plaint in the plaint, I want to read only one paragraph. What is the cause of action for them? Your Russian may kindly turn to page 58. Only
Yes.
one paragraph. Page 58, paragraph 21. Why they sought for this interim order? Page 58.
Yes.
The plaintiff states that certain
No, that page 21 in your this thing.
no, page 58, paragraph 21.
In
In the first paper. There, please.
Page-
Sorry.
para? Page.
Paragraph 21, page 58.
Yes. Yes.
Page 58, paragraph 21. The plaintiff states that certain members of the first defendant had filed a suit in OS number 9 of 2022. For the learned principal senior citizen Karnataka, Telangana. The Honorable Court has granted an interim injunction against the defendant for proceeding with the proposed amendment. The ex parte interim injunction was then confirmed after aiding the parties of marriage by an interlocutory order dated 24/2022. In terms of the said order, the court has directed the proposed amendment to be identical to the subject matter of the suit be put on note with the disposal of the suit. The said interlocutory order is still in force. The plaintiff have also learned that defendants have challenged the said order, putting on note the proposed amendment identical to the one which is subject matter of the suit before the High Court of Telangana. And that is very kindly note the court of Telangana matters.
Yes.
This suit was filed. You also may kindly note the date 9/9/2022.
Yes.
This suit was filed on 9/9/2022. The main catalyst for High Court passing an interim order of injunction was that the matter was seized by the Civil Court of Telangana. Therefore, I could not proceed with the meeting. I obeyed this order. I didn't go proceed with the meeting.
Yes.
Then what happened? The matter came up before the Telangana High Court. The Lordship may kindly go to the memo filed by me yesterday.
But in that suit filed before in the Telangana Civil Court, your injunction has been rejected.
No, an injunction order was passed. My application for vacating was rejected. The main bodies, first
Yes,
respondent. That matter was taken up before the High Court of Telangana.
They have stayed that order.
Yes, your Lordship may kindly see that was stay. Kindly note the date, my lords. The page 1 of my document.
But you have challenged that, they have challenged that before the Supreme Court.
That was negative.
Supreme Court, but the Supreme Court said that we hope that matter will be
Allah,
already discussed.
next order in the Telangana High Court, your Lordship may kindly see. First
Yes.
order of the Telangana High Court is at page 1.
Page 1
Page 1.
in your this
Yes,
thing.
my compilation.
Yes.
ಆಮೇಲೆ ಅವರು ತೆಲಂಗಾಣ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂನೇ ಮಾಡಲಿಲ್ಲ. They are taking time. I can produce the order sheets. Not learned friends claims, others who had filed.
Yes.
Kindly see page 1 of my document filed on 7/3/2023.
Yes.
Page 1, document number 1.
Yes.
This order is dated 15th November 2022.
Page 1, your yes.
15th November 2022 in IA number 1 of 2022 in CRP number 1149 of 2022. Page 1 of my compilation. In that.
Yes. Yes.
Please. 15th November 2000. Date is very crucial. I advanced the case because of this, not because of avoiding an interim order.
No, that this is what that order passed by the Telangana High
Yes.
Court.
Considering the submissions made by learned counsel from the petitioner, the order dated 24/2022 passed in IA number so and so. In place number 9 of 2000 on the file of the principal senior citizen Karimnagar is suspended till 6/12/2022. My lords, this paragraph 21, where 21 of the plaint refers to Karimnagar order. Therefore, this trial court should intervene at the 21 of the plaint. I referred now, page 58.
No, what has happened this matter?
Yes, kindly see my lords further at page 4.
Yes.
Before the matter came up before the Supreme Court, the matter came up again before the Telangana High Court. 7th day of December 2022.
Least on 18/1/23.
The learned counsel is ready for argument, appellant, and that is myself.
Yes.
They took time for hearing both parties based on 18. Interim order granted earlier is extended until further orders.
Yes.
So next matter came up before the Honorable Supreme Court at
Yes.
page 7. Supreme Court said, having heard before this, this order is immediately thereafterwards, I moved an application after the Telangana High Court suspended the matter.
Yes.
The Lordship may kindly see the order sheet in the trial court.
Including the permission expression proceedings, we hope that further permission for the expedition proceedings will be given.
Before the Honorable Supreme Court passed that order,
Hmm.
your Lordship may kindly turn to the order sheet of the trial court at page 24. In the original compilation. We come back to the Honorable Supreme Court's order. Your Lordship may kindly turn to Supreme Court order. I moved an application for advancement.
Yes.
Your Lordship referred to that. Kindly turn to order sheet dated at page 42, 28/11/2022. That's I want to be clear on tax. I don't want anything on tax. At page
No, that I see now I understood that what is the case. What has happened? Telangana, it is pending.
Telangana main matter is pending. They are not arguing. Now what has happened is I moved the order I took the call for the meeting. This matter was advanced. Interim order was not extended. Even then we didn't conduct the meeting. We argued the matter before the trial court. Trial court took 4 days for passing the order sheet and did not pass the order.
No, see, now I am not on that.
No,
concern. That will be decided by the
Trial court postponed the matter beyond vacation. We had to conduct the meeting because some of the officers were retiring. We had to conduct, moderator also was retiring. We had to conduct the first respondents meeting. We wanted to file a 227 petition before this court based on Surya Devi Rai's case of Justice Lavati of the Honorable Supreme Court. That trial court is not passing orders. When we are examining the order sheet, we come to know that the interim order is not extended. I can't come before this court against an order which is not in existence. If the order was not extended, it's not my fault. This was not done. I proposed the meeting in the meanwhile. In the meanwhile, Supreme Court, they moved the Supreme Court. Yeah, I proposed the meeting. Meeting was proposed on 21/12/2022. In the meanwhile,
now that, except in Karnataka, in any other states that he is going to retire shortly.
4 of them have retired.
many of them.
4 of them have retired.
Many of them, including the moderator. One day election at Dharwadalli, he is now re-elected as moderator because of the summit.
In violation of the interim order of the court.
Wait.
In violation of the interim order of the court.
Wait, I am asking them. You can answer when you are asked that. You answer when I am asking. Yes.
My lords, I fixed the meeting on 21/12/2022. Your lordship may kindly note the date. 21/12/2022 for meeting.
No, I understood that
Yes.
now.
No, before that, my lord, what happened? They moved the trial court, petition court, kindly see the order. At
Yes.
page 9, document number 4. This is suppressed before this honorable court. This
Yes.
order is suppressed before this court. A miscellaneous petition was moved for police protection.
Yes.
Page 9 of my compilation.
Yes.
Document number 4.
Miscellaneous petition
Yes.
filed with the petitioner is dismissed.
Yes, my lords, I'll read only one paragraph in the order. Your lordship may kindly come to page 18, para 10.
Yes.
They suppressed one order before the trial court and tried to take an order. Trial court got wind when we appeared in the matter. Kindly see page 18, para 10.
No, now that 2 things.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
I understood everything. There is no interim order when you are passing that.
Yes.
Now that, suppose if he is going to retire, if he is,
ಅಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗೋಯ್ತು. That is infraction.
then I will make it clear that if there is any, this thing, it is only confirmed to that meeting which has taken a decision not to precipitate others.
Precipitate ಆ ಮೀಟಿಂಗ್ ಇಂದನೇ ಮೇನ್ ಮೀಟಿಂಗ್ ಔಟ್ ಆಗಿರೋದು because 16 diocese are voted. One of the diocese is third dependent. ಆ precipitate ಮಾಡಬಾರದು ಅಂದ್ರೆ ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಅದು ಮೇನ್ ಇದೆ.
ಯಾದಕ್ಕೆ?
Main election because
Main, what is that election?
Kindly see the ratification. Your lordship may kindly see this, it will get affected. ಈ document ನೋಡಿ and I will just leave it as that. Document now. Page 9 of the compilation filed by them along with additional affidavit. Yeah, the ratification is over now. That is not under challenge.
Now that how this order will come in their way?
Yeah, precipitate under the misuse.
No. ಅದಕ್ಕೆ ಏನಂತ ಹೇಳಿದ್ರೆ ನಾನು ಕ್ಲಾರಿಫೈ
ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ ನಾನು ಹೇಳ್ತೀನಿ.
ಈಗ ನೀವು you have taken all decision.
Yes.
Now that in any other meetings they are using this,
Meetings are yes,
that I will clarify. That's all that.
no, that were not to precipitate ಅಂತ ಹೇಳಿದಾಗ
ಅದು ಆಯ್ತು. That order is not very clear. I can also precipitate can be used for any other purpose. Now that I will clarify not to precipitate the matter in respect of that meeting.
that meeting is held on 21/12. You are right. But that was not brought to the notice of this court,
Yes.
that on 2112 meeting was held. I sent the ratification to the first respondent. First respondent convened the working committee. Working committee passed a resolution. Since 16 dioceses have ratified, this amendment will come into force and form. They have produced the document in this page infectious. Kindly see page 9. In view of this document, it has become infectious. No order can be passed. This is not under challenge.
No.
They-
That I will consider whether it is infectious or not.
Last submission I make.
No,
Any.
See, Arun, only thing is, now that interim order which is granted by this court, in what way they are interpreting and misusing and coming in their way, that I will clarify.
That precipitate andre that Dharwadalli first respondent meeting ittu. That has nothing to do with this special council.
Yes.
There they went and created nuisance saying that all meeting get stay kotigiran.
Factual
No,
submission.
no, I demonstrate.
If you are happy that
Wait.
I will
I
demonstrate.
counter that virtually.
Yes.
Yes.
Now that
It is the language in this complaint filed before the Dharwad court.
I-
We have been issued notice to
See,
appear before the Dharwad court.
now that suit is only in respect of that holding a meeting.
Suit alla, ಅಯ್ಯೇ ತಗೊಳ್ಳಿ ತಾವು ದಯವಿಟ್ಟು ಅವ್ರು ಏನು ಹೇಳಿದ್ರು against that they can come. They can't come.
Wait. Yes, which is that.
Page 64.
Restraint
IA
of
in
that-
that suit. Only that they can come.
See, I can say that not to precipitate the matter in respect of decision taken on 12/9/2022.
One night meeting ಆಗಲಿಲ್ಲ. Because it was trial court injuncted me from going to the meeting.
When you are taken.
Okay, please.
You only have to talk.
See, this is not fair.
I want to clarify that this thing.
I mean, am I?
I will hear you, Mr.
My part,
No, I will hear you, Mr. Counsel. You see, I will hear you.
my appeal, he's taken the lead.
Yes.
He read my play. He read my IA.
Oh.
Huh? He argued my appeal.
My endeavor before this court is
He's to miss me. That is my endeavor.
matter has become.
Now, whatever may be that between you, before that you two counsel, let it be outside the court, not here. You.
It is happening inside the court.
Page 64.
Now that you clarify how it will affect.
Yes, I left it. Page 64 ಅವರು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರು 12/9/2022 ಮೀಟಿಂಗ್ ಆಗಬಾರ್ದು.
Yes.
Page 64.
Yes.
12/9/64.
Yes.
22.
Yes.
That meeting has taken place instead of 12/9 on 21/12/2022.
21.
12/2022.
Yes.
That is not under challenge before the original suit.
Yes.
Now, trial court has passed an order. Kindly see the order of the trial court. What happened 21/12/2022 is not under challenge. Trial court's order is academic. Trial
No,
court.
that is what that any decision taken on 12/9/2022, not a precipitated.
70 years ಬರಲ್ಲ. ನನ್ ratify ಮಾಡಿದ್ರೆ first respondent cannot pass a resolution because 16 is ಅದು. 16 ಆಗಿರೋ 2/3 ಅಲ್ಲಿ 16 is my vote is very important. My ratification. ನಾವು ಅದನ್ನ ratify ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ then 16 people have to ratify 2/3. Now correctly 16 have ratified. If I don't, my ratification is not accepted, then that vote will become.
No, when you have ratified
21/12/2022.
21/12/2022, ratification is subject to the result of the suit.
Yes.
Then you take any further, you should not take any further.
21/12/2020 is subject to result of the suit. I am acceptable. Not beyond that, my lords.
No, you saying that you have already taken a decision.
Yes, my lords may kindly see one. Kindly see page 25.
Yes, I heard. Yes, Mr. What is? Yes, you can.
32 minutes.
Yes,
I hope I'll get at least half of that.
yes,
And I hope there won't be any interference.
yes.
Clarification suggested by the Honorable Court that the order passed by the Honorable Court on 12th of January 2023,
Yes,
that there will not be a precipitation by the respondents. My lord was pursuant to my interlocutory application. Interlocutory application stated the proceeding in haste to ratify the amendments. Because they need 2/3 of 24
yes,
diocesan councils.
yes,
They are including the Karnataka Central Diocesan Council, relying on the meeting of 21st of December 2023.
Yes.
Therefore, we said that the ratification of the amendment to the Constitution, which is going to be held shortly, the basis of this illegal meeting in our respective submission held on 21st of December, should be stayed. My lord was convinced and my lord passed an order.
Yes.
The order was very clear. What said? Let me highlight.
Yes.
Yes. I refer to the 12th January 2023 order, my lord.
Yes.
It says, these objections have to open, issue emergent notice to the respondents.
Yes.
The learned counsel for the appellant is also permitted to take out hand summons to serve the respondents.
Yes.
The learned counsel for the appellant submitted that during the pendency of the matter before the trial court, the appellant had the benefit of an interim order directing respondent number 3, who is the defendant in the suit, restraining him from conducting the special meeting of the Diocesan Council on 12 September 2022 till 1 week. Same has been continued till the disposal of the application, that is on 3rd January 2023.
Yes.
During the winter vacation, what we kindly note,
Yes.
during the winter vacation, the matter was reserved for orders. Full stop there.
Yes.
On full stop before, after orders, full stop.
Yes.
On 19th December 2022, not kindly
Yes.
recall, the first day of winter vacation, the respondents have conducted the meeting on 21/12/2022. Now, notice of meeting was issued on 19/12,
Yes.
and meeting was held on 21/12. Not even a day's notice, though my constitution requires 2 months notice to be given to the diocesan council.
Yes.
I will point out that constitution provision also.
Yes.
And more importantly, when the matter was heard and the matter was reserved for orders on 3rd January 2023, this is done when the courts closed for vacation. The first day, 19th of December, they issued notice. Less than a day's notice, meeting is hurriedly held at 9 a.m. on 21/12/2022.
Yes.
And on that day, they took a decision contrary to the interim order granted by the trial.
Yes.
He further contended that in respect of violation of the interim order granted by the trial court, he has filed a contempt petition, which is true. In view of the above, the respondents are directed not to precipitate the matter till the next date of hearing. Now, this one order was passed on 12th of January 2023.
Yes.
A meeting was held. Before I go, I will point out that this order was completely disrespected by the respondents.
Yes.
On 13th January, when this hand summons was issued to us, we collected the hand summons on the 12th evening at 5:30 p.m.
Yes.
The court office had took some time to prepare the hand summons. We got it at 12:30. My lord was very kind enough to issue hand delivery of the order. Armed with both of this, we sent emails to the respondents at their official email address because the office of the respondents closes at 5:30 p.m. We could not effect a physical service. We conveyed it by email. We also, since the hand summons was issued, we also took it to the venue of the meeting. For this meeting held in Hubli within the jurisdiction of my lord's court was on 13th morning.
Yes.
And in the agenda of the meeting, the 13th, the ratification was at 5 p.m.
Yes.
In their own agenda.
Yes.
The appellant met with his counsel, a junior of the counsel appearing in the trial court,
Yes.
approached the venue. They prevented the appellant from entering the venue. But seeing an officer of the court with a hand summons and the seal of our Honorable High Court, they allowed him into the venue. The advocate went into the venue. Meeting was just about to start. He approached the respondent directly and he explained to them that this is a summons I've been directed to hand it over to you by the Honorable Court. The respondent, who is supposed to be the spiritual head of this organization, saw it and refused to take it. And this respondent, who is the secretary, instigated those present on the dais to physically evict the council from the premises. In that counsel obviously was not prepared. He was taken aback and obviously was, I can't explain in a configuration where your counsel appearing there. He was obviously frightened. He tried to exit. There was some kind of force exerted on him. He was injured. There was attempts to physically pull the hand summons issued by this court. He made his way out. He had to take treatment in the government hospital for an injury which was suspected to be a fracture, but thankfully was not a fracture. And those proceedings concluded. Police, it became a medical legal case. Police complaint was lodged. Police officer, on seeing the hand summons of the court, thought it fit that it was his duty to have offered protection. It was not requested. The officer in charge of the jurisdictional police, on seeing the hand summons of the court, was of course taken aback. How is that order of the highest court of state has been disrespected in this manner? Yes. He took the initiative of taking the counsel again at 4 p.m. to the venue. At the venue, the fifth respondent, the secretary of the CSI, yes, the video, the police took the video. The police officer took the video. He presented the hand summons. The police officer also was conscious of the fact that it was a spiritual, supposedly a spiritual congregation. He stood outside and said, "Sir, the hand summons, take it, or you want to refuse it? Refuse it." This is an exercise which we have to do in law. He said, "Sorry, I will not take it." Now, that is captured in the video, which is submitted to the court. Police officers done. He gave an endorsement in his report, which is forming part of the proceedings in the FIR, that the fifth respondent refused to accept the answer. And then we find the 39A. They went ahead on 13th of January 2023, held a meeting, declared all of them elected, claimed that all ratifications have happened, bulldozed the entire thing, stage managed everything and declared it. Now, we came back here. We have submitted to the court the return of the hand summons. We have filed an affidavit. We have filed a 39-period proceeding. First and foremost, in a situation like this, unless and until the respondents purge themselves of a contempt which is as blatant as is evident from the records, there is technically no audience. Now, assuming for a moment none of this has happened, there is no pleading on record, even asking for a modification of the interim order. In what respect, I do not understand. The Lord may kindly appreciate the manner in which the matter was advanced. He said, very misleadingly he put it, the order was listed for a decision on 3rd of January 2023, which came in his favor. The reason not to wait for 3/1/2023, whatever it is, there is an interim order. Whatever it is, his remedy can be only in law. He issued on 19th December a notice. The notice would say on the instructions of counsel, we are holding the meeting. Yes. And they refer to the Telangana case, which has no relevance to our proceedings here. He referred to the Telangana case in the argument before the main matter. The court had considered it and taken the Telangana order into consideration and passed the order on 3rd January. The court was seized of the matter. To move on 19th December, my respectful submission, there was no reason whatsoever. My lord, that meeting could have been held 4th January, 5th January, 6th January. He's retiring on 11th February or 12th February. My lord, they had the whole of January. My lord, may I make the submission? My lord, the summons was refused. The record is on the court. He appeared on, kindly see the order. He appeared 20th January.
Yes. Yes.
On 20th January, he appeared. He knew that this man is retiring on 11th February 2023. What should my learned friend do? Move an application for a modification, call for an argument. And the court would have then considered the matter and then decided on my. In fact, when I started this morning, I requested the court to decide the matter on merits. From 20th of January, even till today, as we make this submission, my lord.
Yes, yes, you can argue more than that. What is time?
No, subject, of course, my lord may curtail me at any time. I'm out with court's directions. 20th January onwards, no application is made to modify. Today, I don't see a single pleading, my lord, to counter my application for interlocutory application or seeking a modification to the order, which my lord was very kind to hear my learned friend, where he tried every permutation and combination to avoid the suggestion of the court. And the court was so very reasonable in saying that precipitation means pursuant to the meeting of 21st December 2023, which is all we are seeking. Kindly note on the I'm baffled. Kindly note the advancement application. What was the reason to he advanced it? Fair enough, he advanced it. He argued the matter. There was no request that there is in his argument for the honorable court. There was no pressing of anything urgent that the order should be passed by any particular time. There was no such submission at all, my lord. The order went back to the original date of 3/1/2023.
Yes.
There was not a whisper of a submission by the other side that they will suffer any prejudice if the orders were not passed immediately. In fact, in his advancement application, if the lord sees the averments, it is not even filed by an affidavit of the respondents. It is filed by a memorandum of fact of my learned friend. He has basically conducted this case as his personal case. May I draw my lord's attention to the advancement application? My lord may kindly have a look at it. It is entirely signed by my learned friend with memorandum of facts. There is no averment of the respondents. I mean, these are judicial proceedings. These are serious proceedings in law. We are in the highest court of the state. And my lord, even today, even the matter was advanced by memorandum of fact. Is he conducting this case as a person in person, or is he conducting the case as counsel for the respondents? I feel he moves an application in completely bizarre. The respondent should aver that they have some urgency. They advance the matter on a memorandum of fact by the learned counsel. I will point out to the court where that is. Court advanced the matter, heard it on merits in a day. The day it was heard, posted for orders on 3rd January. Where was the need, my lord, to have this notification issued on 19th of December on the first day of winter vacation at the behest of the council on record, to hold a meeting a day later at 9 a.m. on 21st?
Yes.
Therefore, my lord, that meeting in the 15th of the order of the court is null and void in my respectful submission. And that is how this honorable court was pleased to grant us the interim order. And I find today there's nothing at all which is coming in the way of the interim order being vacated in any respect. Modified to what extent? There is no application seeking modification. There is no affidavit of the respondent on record justifying to the honorable court. Nothing is on affidavit. Will this court decide on facts, on the oral submissions of counsel? Has this ever been heard of in the law of pleadings that the court will be called upon to amend its order on without an application for amendment, without reasons being set out on affidavit? At least if he sets out on reasons for affidavit, I will counter it by taking instructions from my client, and then I will point out where and how falsity has crept in. This kind of a procedure I am not exposed to. Prima facie, the order is wrong. My lord, lord's order was 12th January 2023. Meeting is held on 13th January 2023. References made to a lot of Telangana High Court matter. May I point out this? In Telangana law, suppression again. There are 2 proceedings in Telangana. My friend has highlighted to my lord only 1 proceeding. There's another proceeding which ended up in an order subsequent to the orders. My lord is in possession. And his clients are parties there. I am not there. And that is not produced before the court. So even here, suppression selective.
What is that other proceedings?
My lord, that order was passed. My lord's order was on 12th January.
Yes.
That order was on 11th January, a day before this court. My lord's court passed the order. On 11th January, the Telangana High Court passes an order restraining them from holding any meeting more specific than my lord's order.
What has happened that?
That matter is still pending.
Yes.
And they hold the meeting in violation of The order of 11th January 2023, specific order not to hold any meeting. They hold the meeting on 13th of January 2023, but complete. My lord, as I see.
Even in that Telangana also, they have did it contrary to that. Order.
Absolutely. I'll show the order right away.
Yes.
So here is the party, the Church of South India, my lord. The brief.
No, you take it. No. Where is that order? You have the copy.
It's,
I know that both the council will take more time. Therefore, I said 2:30. Even the courts also knows that which court, which advocates take times and how. Yes.
My lord, when I started, 1 minute, sir.
Wait. I'm not.
My lord, when I started. No, if you are wasting my time.
Yes. Yes.
It's the last page, last two lines.
Yes.
Further, the revision of, my lord, has it?
On perusal of that impune order.
Yeah, kindly come to the last line.
Yes.
Further, the revision petitioners are also directed not to take any further steps, like proceeding with the meetings, etc., from today onwards till 19th of January 2023.
Yes.
They hold the meeting 13th January. My lord's order is dated 12th January.
Yes.
And may I make a submission? A document produced by my learned friend in the trial court in respect of the interim order my friend is referring to. He had approached the Honorable Supreme Court of India against the proceedings in the Karimnagar court, which my lord is very neatly produced in the compilation. My lord will see the first order of 1511 is the High Court of Telangana. The proceedings in CRP 1149 of 2022.
Yes.
It arises out of a suit of 2022.
No, one thing. Now that you file an application with that all documents, let him also give an objection. I will consider and pass an order. Then it is for the parties to take into that matter. Otherwise,
No.
Wait, Mr. No, Mr. You take your now that
I will not shy away. All right.
Very unfortunate, my learned friend is suppressing a Telangana hard copy. I'll clarify that. Telangana hard copy.
yes, you both of them placed by that this thing affidavit. Then I will see that.
Please.
Now that what is that apprehension for you? Now you have already, in spite of that order, you have conducted.
My meeting 22/11/2022. Therefore, that will create reasons for me. 2022 meeting is creating nuisance.
I have to clarify my order. I want to know whether it is wrong or right. Let him make.
Spent about half an hour trying to explain that. He still wants to
This
say.
is very unfair on my learned friend.
Really, we know that.
Application is filed before this court, contrary to the application which was filed in the trial court.
You already said that. You already said that.
MFA Barado against the trial court application and order.
See,
A
my lord.
different application is filed before this court. Kindly see the application.
No, if this is going to go on, he said this for the fourth time.
Now that
He said it for the fourth time. No, he said it for the fourth time.
He is preventing me from my article. Can you see? The logic of the effect. This is against.
Then in that case, this is the matter for hearing. We'll argue.
no, I will not pass any order. Call this matter after 4 weeks.
The interim order.
What is this, Mister? This is a court or something? You both are arguing each other. I have given a sufficient time to both. When he is arguing, you are interfering. You are arguing that you are interfering. I have to decide if you order like this, how can we?
My lord, may extend the interim order.
No,
I mean, what? I mean, I don't know. You oppose for what?
see, if you want to
No, no,
clarification, wait, Mister.
No, let me be
You
very
want
clear.
to file an application because my order has to be passed on that your affidavit. If you are aggrieved persons can take it to the Supreme Court, but nobody is producing that.
Based on the records. Based on the records before the election, that application filed before.
No, you place all that on the record.
the.
No, that by an affidavit of the parties, I will consider given a survey.
Let them
Yes.
know.
The extension of.
No, if that is- No, no, this is not correct.
Wait, mister. How it will affect?
Yeah,
your-
yes, kindly see the Chennai court order. It has permitted the meeting in Dharwad. They want that your orders, your lordship's order to be applicable to Dharwad court also.
No, that is not that.
Your lordship may clarify that.
Yes.
Is
Dharwad meeting is for what purpose?
the meeting of the first respondent, not of the third respondent. The application filed by this court is in respect of third respondent.
I thought he
Kindly
had,
see the Chennai
no,
court order.
I thought he had his say, and then my lord heard me. Now
Yes.
then
You
I
want to confuse.
One
Yes,
minute,
yes.
sir.
He.
1 minute, sir. 1 minute, sir. Then to come out and then my lord is satisfied.
His contention
To come out,
before the
you
court.
not like this.
Contention before the trial
No,
court
no,
is.
if you want to win at that is the agenda.
Mr. Counsel, are you in that court or you are arguing that with that your parties? What you want to submit is submit to the court. This is a court. You are across the bar, you are fighting. Yes,
Madras.
I will, no, that this will not come in their way of that your meeting to be held in that Dharwad. Where is that Madras court order?
Your lordship, passed it.
Yes. Interim order granted and 12/1/2023 is clarified.
You know the Chennai court order. Chennai court.
It is clarified.
1 minute.
No, you don't say 1 minute. It is for me to pass an order. I have heard you, I will pass an order.
Where you are not heard me on the Madras
Yes.
order.
No, I am not on that Madras
My
order.
lord,
1 minute. Don't get me. Don't shoot the messenger.
Yes,
You are
that is
shooting
what,
the messenger.
that is what you both are doing. That. No, see, that
Don't
is
shoot
what,
the messenger.
yes.
Don't shoot the messenger.
No, that is what that you both are doing that. in
I'm
the
not
court.
doing anything. I'm not doing anything. 1 minute. One minute, sir. You're all your time. Quota of time.
the Chennai court
I
is.
finished. 1 minute. He had 35 minutes.
Yes,
And when I started, I made 2 requests to the court.
yes,
I will take half of it, if not full of it. And I also requested the court there will not be any disturbance.
yes.
I believe that as a counsel, I'm reasonably entitled to so much of indulgence from the court.
Yes, you make sense. Yes,
If it is such a thing, then
yes.
I don't have to see at the end of the day, my lord is taking a decision.
Yes.
I pointed out to the court that if there has to be a modification of that, that has to be an application. It is not happening. And I don't see how the court, frankly speaking, correct me if I'm wrong, in my 30 years of experience,
Yes.
the way court decides these matters, I mean, if I'm wrong, my lord will correct me. There has to be an affidavit stating the grounds. Then my lord will obviously overrule me or a response thereto.
Yes.
It cannot be off in this manner. And he had his say for half an hour, where he did not refer to the Telangana order, which I referred to, my lord. And then when that comes out of the bag, he comes out with the Madras judgment.
Yes,
My lord, this is not correct.
yes.
The sequence of events in Madras are entirely different from here.
Yes.
No,
It is
one-
still-
No, sir.
This is how that, when he is arguing,
Yeah, sorry.
this is whether this is an
I
court
am-
or something. Yes. Yes,
You wanted to read the Chennai order.
yes, let him,
Yes.
let's,
May I ask, why was the Chennai order not read when he
Yes.
had it, all the things?
yes,
And I was asked to respond to him as an
Yes.
appellant
yes,
after hearing the respondent first. It was a very unusual procedure.
yes,
Since my lord wanted to hear him and my lord heard him.
yes,
And then my lord gave me an opportunity to respond.
yes,
And then again, a further argument after response
yes,
with no pleading on record.
yes,
Well, may I make this submission to the court? It's all a fight for power. There is this man who's retiring tomorrow. And that was known to him, not now. It was known to him since he put his papers on 20th of January in these proceedings. To gate crash at this moment on the 9th of February has only 2 reasons. He wants to avoid a hearing on merits, which could have well have happened if there was an urgency in the matter from 20th of January. 20th of January, there was never a move
yes,
citing that the 4th respondent is retiring on the 11th, and therefore I need a modification of the order. My lord would have heard us and passed a considered order. It was not done. On the 9th, day after tomorrow, he is retiring. not a single application for modification. There's nothing on record to show why this court should amend the order.
Yes.
Am I not being prejudiced by this?
Yes.
Ideally, should he not have filed an application? Is he going to be treated by a special, exemption from the procedures of the court?
Yes.
Isn't it fair for the other side to know why he wants the modification? And my lord, when the order was passed on 3rd January 2023,
Yes.
we had the benefit of an interim order. My lord, now may I make this submission? There is an order to Telangana High Court not to conduct any meeting. There is an order to Madras High Court. There is an order of my lord's court. 3 orders are passed. Judicial committee between the courts of the Union of India is to ensure that the high courts are also respected. My lord is a high court. So also is Telangana. So also is Madras. The only interpretation, my lord, will have to take is an interpretation which sustains the order of all the 3 courts. My lord is not called upon to pick and choose between Madras and Telangana. My lord's order is in tune with the Telangana High Court. May I know what earthly reason is there to leave out my lord's order, which is in tune with the Telangana High Court order,
Yes.
and to go by the Madras High Court order?
Yes.
It would only mean disrespecting my lord's order
Yes.
and the Telangana High Court order.
Yes.
My lord, may I make the submission?
Yes.
My lord's order and the Telangana order is not contrary to the Chennai order. The Chennai order is a limited order. The Telangana order and the Karnataka order, my lord's order, is a larger order. 2 high courts at this moment have passed an order
Yes.
restraining complete meetings. Madras has passed an order, conduct the meeting, but meetings will not be given effect to, resolutions will not be declared. So that is a lesser order, not a complete clean sheet for him. He is celebrating the order.
Yes.
Is my lord
Yes. 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 You.
Yeah.
Yes. Yes.
my lord will not pass an order
Yes.
which would in any way come in the way of a high court of another state when 3 high courts are seized of the matter. My lord's continuation of the interim order will not come in the way of the Telangana order, will not come in the way of the Madras order. The all-encompassing order. Therefore, my respectful submission is, I want to hear the matter on merits. If he is going to retire on 11th, the CSI is not run on the basis of one pusher. This entire exercise is to stay in power by one individual, and it is very sad that the scramble for power has not even left a spiritual body and congregation. In fact, the scramble for power seems to be more higher in the spiritual body.
Yes.
Considering the fact, may I make the submission? The Constitution, give me the Constitution. 2 things. The Constitution of the Church of South India, my Lord, has been produced. It provides for a period of 2 years to ratify or otherwise of the resolution to amend the Constitution. For 2 years. Kindly see page 177.
Yes.
Now, I don't have a copy with me, but my
Yes.
lord will see.
Yes.
My lord reads that page 177.
Yes.
The time limit for ratifying an amendment to the constitution is 2 years.
Yes. Yes.
So, to violate the order of two highest courts of the state, Karnataka and Telangana, and to rush up to the meeting on 13th of January 2023, when the diocesan councils have 2 years to consider it, speaks volumes of malafide. Second, the Karnataka constitution, the central diocesan constitution, provides for meetings against the teeth of the order of the trial court after hearing the matter on merit and posting the matter for orders on 3rd of January 2023. 19th of December, first day of winter vacation, they issue a notice. Some of them have not received it, the diocesan council members. They claim to have issued a notice on 19th of December 2023, scheduling a meeting on 9 a.m. on 21st of December 2023, which is the meeting where they claim that they have ratified. My lord, when the constitution provides for a 2-year term, who has heard the matter on his advancement? We had a complete say in the matter. Matter was listed for 3rd January 2023. 2 years time is there. You move on 19th of December, hold the meeting on 21st of December on council's instructions. They say in the notice of meeting, we are instructed by our council. There is no hurdle. Conduct the meeting. Meeting is scheduled at 9 a.m. on 21st December 2023. They conduct the meeting. The constitution of the Karnataka Central Diocese, that is the constitution of the main body, which provides for a 2-year term. The constitution of the Karnataka Central Diocese provides that a minimum of 2 months notice for a meeting is required. On the top, the ink.
Yes.
Yeah.
Yes.
In violation of an interim order, in violation of the constitution of the Karnataka Central Diocese, he wants to live by that order, which my lord very rightly said no precipitative action will be taken pursuant to the prima facie illegal order. And my lord, may I make this submission? My lord has seen Telangana, the latest judgment in Telangana, which pales in the significance whatever he has produced.
Yes.
This is all what he has produced is earlier.
Yes.
I have produced the January order.
What has happened after that? 19/1/2023.
It got adjourned. No, I'm sorry. 19/1/2023, the matter was referred back to the trial court with an order that the state interim order granted here will remain in force until the matter is heard on merits. Now, all of that is suppressed. He was a party there. Suppressed. And my lord, may I make the submission? 3 orders which he has produced. I need not submit this, but I want to explain to the court how they play with the judicial system. This is baffling for me. Lord, this suit, I'm referring to only what he has produced. I'm not referring to the subsequent order. The Lord will see these 3 orders for 2 of the High Court of Telangana, suspension, and the order of the Supreme Court of India, pursuant to that, was all passed by suppressing an order of the Supreme Court staying proceedings of the Telangana of the Karimnagar court. When an interim order was passed, those proceedings were stayed pursuant to a transfer petition filed by them, the Honorable Supreme Court. And they found it very convenient, probably, to get an order of suspension of the Telangana High Court. Therefore, they didn't bring it to the notice of the Telangana High Court about the stay order of the Supreme Court. And this stay is still in force.
Both of them are taking one by one.
No.
Wait, no, see,
No.
wait. Arun. See, there may be a Chennai court order. See, even that Telangana court has.
Telangana court is in favor of government. Explain Martin. That Telangana court is in my favor is misleading.
Now that interim order will be continued, if you want to file any application.
That's one thing. Your Lordship may say.
This is what that, see.
My Lordship may say, the 27-12 meeting is subject to final decision in the suit. Otherwise, it will create disputed andre police ki naale they have announced that there will be a
What is the meeting tomorrow?
naale illa bishop is returning on day after tomorrow.
Wait, Mr. Yes.
I'll tell you, give me the time. You ready? Telangana order.
Asking for the order.
That's all.
You suppress the order. Not fine.
Supreme Court immediately state all the proceedings before the Karnataka court. The presiding officer is transferred to Jettia. If he passes an order, again, in respect of the same matter, with great respect to the this one. That order is challenged before the Telangana High Court, saying that very same presiding officer who passed the order, that the proceedings are stayed in our matter before the Supreme Court. He passes another order in this matter in Jettia. That order in extraordinary circumstances.
See, Madras High Court said, you go ahead with that meeting, but not to give effect that.
No, can we see the last
word that you go ahead with the meeting, but not give effect that.
Yes, your Lordship may clarify. We have the Madras High Court.
No, you conducted a meeting, but not give an effect.
No, not effect. That is not the order. 27 meeting will not affect the problem of the because of the Madras High Court order. When is the operative portion of the order? Before that, my Lord's place, can you see the Telangana order?
No, that is not that. Now that Madras.
He said in his favor, I read the Telangana order. When you read this order, my Lord? Madras order, when you see the Telangana order, he passed down. When you see that order?
No, that one copy you are all circulating. Other new ತಗೊಂಡು ಓದಿದ್ರೆ ನಾನೇ ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲ.
Oh, I'm sorry. Lordship may take judicial notice of this.
Yes.
Whether a person like this is entitled to an interim order.
Yes.
I great respect. Telangana High Court removed the Telangana High Court against the Dithyal order. Telangana High Court passed all this in our paper, set aside the entire proceeding before Dithyal and said you are not follow the procedure. That is in my favor. When we see the Chennai court order. Can I ignore the Chennai court order? Can this court interfere in the matter? Please see the Chennai court order. At para 9, last sentence. In order to balance the equities and strategy, para 9, last sentence.
Yes.
In para 9, in order to balance the equities.
Yes.
Para 9. In order to balance the equities at this juncture, because this matter was moved on 12th.
Yes, you read that.
The meeting in Dharwad was on 13th.
Yes.
The following order is passed. The conduct of the ordinary election is not restrained subject to following condition. The entire proceedings will be recorded by electronic appropriate equipment, and such audio visual recordings will be submitted to this court at the next hearing. The elections will be conducted by adopting the ballot process plan fixed in the Constitution. The results of the elections shall not be declared until further orders. All office bearers who are elected to have been eligible for amendment shall not be entitled to pay iniquities in the favor of the independent applications are taken up for disposal subsequently. My lords, this will protect their interest. This unfair order by all office bearers who are elected to have been eligible for amendment shall not be entitled to pay iniquities in the favor of the independent applications are taken up for disposal subsequently. In the direction by above, implement office bearers shall continue to hold office until further orders. My lords, the entire comprehensive suit is before the Madras High Court. It has original jurisdiction. Now this order is passed. In the teeth of this order, and this honorable court says not to precipitate
No,
respect.
what is that election you are going to help?
Which election, my lord?
No, that you election ballot paper and all that.
That is held in Dharwad. That Chennai office meeting was held in Dharwad this time because Dharwad has northern diocese. Because ours is
No. What is the elections?
Synod, that first respondents office, there is moderator, general secretary, and all the posts. They got the benefit of the 70 years. They were elected.
Yes.
Pursuant to that. Now, if your lordship says not to precipitate, these orders will get nullified.
No. For election, see, amendment shall not be claim equity in their favor.
Yes, that is what your lordship may kindly say that. That 27/12/2022 meeting is subject to result of the suit in Chennai.
No, that what is that office bearers who are elected?
The benefit of 70 years was granted. Your lordship may
No, how that elections
Yeah.
were?
kindly see only one document. Your lordship
No,
may-
you just explain that.
Page 9 of their compilation. I leave it at that. I did not interject when he was talking. He should be a gentleman before this court. Kindly see one page.
I will argue the matter on merits.
Yes, both are argued. I will
No,
pass
only
it on.
one page, that's it. The effective ಬಂದ್ಬಿಟ್ಟಿದೆ. Not how you relate back on that. This is not under challenge. Kindly read that. But permit me to read the words.
Which is that?
In the compilation of papers along with the additional affidavit filed by them.
Yes,
Your lordship will get it along with this affidavit.
yes,
IA number additional affidavit.
yes. Yes, yes.
These documents, your additional affidavit. Along with IA number 1, additional affidavit in support of IA number 1.
Yes,
One document article which makes this infectious and the suit infectious.
yes, application.
Additional affidavit.
Yes.
No reply to my additional affidavit.
I
He
will-
will argue off the cuff, and I have to respond to that.
Yes, yes.
Without-
Yes, Yes.
27th, page 9.
yes.
Page 9. Page 9.
Yes, yes.
27 December 2022. Some
Yes.
meeting ಆಗಿದ್ದು. I read that this one, our meeting was held on 27/12/2022.
Yes.
After this meeting, this is by first respondent. We are to the all the bishops, moderators, service church of South India. We are respected. This is to inform you that we paid 16 diocesan councils of the church of 22 existing councils. I met for ratification of the resolution principle amendment to constitution of the church of South India and passed the special session of the synod held at Bishop's College Trichy on 7/3/2022. Out of the 22 diocesan councils, 15 councils is among the 2/3 thereof have ratified the said amendments. In view of the ratifications in the required number of diocesan councils having been received, the synod working committee met in the synod situated at Chennai today to Zoom and examine in detail the reports received by me from the 15 diocesan councils selection herewith. The synod working committee thereafter resolved as follows. It is therefore resolved that the ratification of amendment to the Constitution of the Church of India by 15 diocesan councils constitutes 2/3 of the said council. As contemplated in chapter 13, rule 2 CF page 160. While amendment then requested the court to read that of the Constitution is in order. Authorize the general secretary to return the amendments to come into force on the date of such communication. Consequently, I have to declare the amendment shall come into force on the date of that is today, 27th of December, as being the law of the sentence of the given to the letter and spirit thereof. This order is challenged before the Chennai court. This order is not being challenged before this court.
Yes, thoroughly. Today, when the matter is posted in the orders, the council for the respondent has objected for extension of interim order. Around that, only add interim order has been passed. There is no absolute interim order has been passed. See, so and so learned council appearing for. The appellant has contended that he has a benefit of interim order before the trial court. Trial court has granted an interim order on 12/9/2022 till 1 week. The same has been continued till the disposal of the application.
Next date of hearing. Next date of hearing.
Next date of hearing. Next date of hearing is fixed on
4/2/2023 on the last occasion.
yes 4/2/2023. The matter has been disposed of on 3/1/2023. When the matter is reserved for orders, they have conducted in a meeting contrary to that interim order passed by the trial court. He further contended that even as per that the Constitution of the Church of South India, as per chapter 13, for ratification of the decision of the council has to be done within 2 years from the date of circulation of the amendment. He further contended that even as per that Karnataka Central Diocese of the Church of the South India to call any meeting, they have to give 2 months prior notice. Without following this procedure of law and contrary to that interim order passed by the trial court, they have taken a decision. Therefore, the interim order has been granted not to precipitate the matter in respect of decision has been taken by the respondent. He further submitted that there is no any application has been filed for modification of the interim order. Hence, he sought for extension of the interim order granted by this court. And he has also relied on order passed by Telangana High Court on 11/10 as follows. For contra, so and so learned counsel appearing for the respondent has submitted that this court has granted an ex parte ad interim order. There is no any absolute interim order has been granted. Interim order granted till next date of hearing. Hence, he contended that the prior sought in that suit as well as he's become infectious. Therefore, he is not entitled for continuing any interim order. He further contended that the ex parte interim order passed by the trial court on the basis of the order passed by the Telangana High Court in where you have produced that.
Telangana High Court.
Yes.
There is a memo dated
Telangana High Court in CRP number 1149 of 2022. Alala, yes. That order has been challenged. No, that is Telangana High Court has passed an order. No.
Go ahead with Karimnagar court's order was suspended.
Yes, sir. Yeah,
The suit is based on Karimnagar court.
yes, suit is based upon. Yes, that is. Recording is submission. That, yes, yes, yes. Submitted that. Which court?
Karimnagar court.
Karimnagar court has passed
An order during.
has passed an injunction order restraining the defendant being agreed by the same. The Church of South India is the defendant has filed an CRP in Telangana High Court in CRP number 1149 of 2022. The order passed by the Karimnagar Civil Court has been stayed, suspended. That has been challenged before Honorable Apex Court.
Page 7. Further extension, page 4. And then further orders.
Yes, where is that? Page? Supreme Court judgment.
Supreme Court 7. No, but Telangana Court.
Yes. Before that, Supreme Court in SLP number 21824 of 2022 on 9/12/2022, Apex Court has dismissed that appeal, directed the High Court to dispose of that civil revision petition as expeditiously.
Next order of the 1 page next order of the trial court extension argument, they moved a trial court for police protection.
Yes, yes.
Additionally,
Yes, that is not yes.
only 1 page.
He further contended. Yes, you take.
Please.
He further contended that. A similar matter is also pending before Madras High Court.
Challenging the main resolution.
Yes.
Challenge Madila.
Yes, yes. We contended that the matter is
Decision dated 27 December.
decision dated 27 December 2022.
Is under challenge before
He
the
is under challenge before the Madras High Court.
and it is not under challenge.
Wait,
before-
wait, wait.
Sorry.
Madras High Court has passed some interim order. Now, in view of that interim order passed by this court, it is respondent can't held any meeting. Hence, he sought for he is subjected for any extension of the interim order or the learned counsel for the partition. This court on 12/1/2023, after hearing that applicant has granted an interim order directing the respondent to not to precipitate the matter in respect of meeting.
Special meeting of the diocese.
Yes, special meetings of diocese. It is now brought to the notice of the court that the meeting has been held on 13/1/2022.
27/12/2022.
Huh? 27 by the doing a pendant. Wait, adral innon ಸೇರಿಸ್ಕೊಂಡು our contention ಅಲ್ಲಿ. See, this court has granted an interim order on 12/1/2023 when they want to furnish the same to the respondent regarding interim order passed by this court and summons. They have refused to take the same.
That meeting is different. What they
No.
wanted.
That is contention.
Synod meeting. Synod
Yes,
meeting.
yes.
Meeting.
Refused to take that order passed by this court, and they have proceeded to held in a meeting on 13/1/2023. Yes.
Also in violation of the Telangana order.
Yes.
Idu 27/12 meeting.
I understand. Yes. Now that
Madras 13/1 meeting was permitted by the Madras.
wait,
13/1 meeting was permitted by the Madras.
both of them has allowed
I
me.
just clarified to the court. Very good. The Karnataka Central Diocese held its meeting contrary to the constitution on 19th notice, 21st December. which is per se illegal and in the teeth of the order of the.
Yes,
interim
yes,
order.
yes. That's I
That
understood.
that is one thing. Follow up of that, my lord should understand this. Synod meeting, which was held on 13, was also restrained by an order of this court and the Telangana High Court. You all will see, the Synod needs to have 2/3 of the Diocesan Council. Now, if the Karnataka Diocesan Council is taken away, as it is, the 2/3 doesn't come in. And the interim order of both the Telangana and my lord's order is very clear, operating against all the respondents, not to hold the meeting. They should have simply, and when 2 years is there, they should have indulged in legal remedies coming to this court. They lost in Telangana. Telangana has said the order will continue till the matter is disposed of in the trial. They should have come back to this court. Then argued on merits, filing their pleadings. They
No,
didn't do that.
no, that they have taken that such a courage to violate, they will face that contempt. I'm not on that.
Contempt is penal. That will happen.
Now I have heard, now I have heard both of
Yes,
them.
that's
I will
all.
pass an,
I'll put the scheme of things.
we will pass an order. Any person aggrieved can go to the Supreme Court.
27th or 21st.
21st. They have taken a decision on 21st/12/2022 on the ground that the interim order passed by the trial court was not in the force on that day. See, Madras High Court had also taken note of that. Constitution of CSI and granted an interim order as follows. In view of the above, the interim order passed by this court dated 12/1/2023 is modified that any decision taken pursuant to that meeting held on 21/12/2022 is subject to result of this appeal and parties cannot be claimed any equity. Yes.
For 37, case is Sudarshan for appellant Dhananjaya N.
Yes. Main matter.
Because
No, that is
it
not
can't be
that,
left in limbo, right?
that is true. That
I mean,
no.
Judicial function today logically
Now
comes
that,
to close.
now that you have to pursue that contempt.
Contempt will happen.
No, because prima facie there is a violation of the court order. You have to see that court order has to be obeyed. That is different.
We are not interested in penalizing people.
Yes.
We are interested in upholding the rule of law.
Then 28th or first week of March.
28, first week of March, 28, please, we have 28. May I make a request to the court that it will be taken up for disposal so that.
No, in next is only the further disposal.
If my lord may mention that it's an urgency in this matter.
Yes, on 28th you see that.
Yes.
On 28th or first March.
The interim order extended on the modification. 1 minute, sir.
Interim this order.
Your interests are well taken care of. Now relax.
Yes, I understood. Interim order is still next date of it.
I'm grateful. As modified, sir.
Why you people are very. Yes. That is what that after passing all, like after passing all this order, I can say that interim order took was earlier. No, both of them don't step into the shoe of that parties. Already, this order until Arun, I know that.
My lord is clear.
Yeah.
If he wants it in writing that he will be the bishop forever,
Yes,
you can pass that order.
Yeah, you both, now that you both, now what outside, Arun, both of them, both, my, yes. Yes, yes.
He wanted.
Yes, yes, yes. Yes. Yes, Mr. Sudarshan, what is this? Oh, this is the. ಎಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ?
ಬಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ
ಏನಂತ
ಅಬೇಟ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಡಿಲೇ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅವ್ರ
ಅವ್ರದ್ದು ಅಪ್ಲಿಕೇಶನ್ ವಿಲ್ ಬಿ ಕನ್ಸಿಡರ್. Yes, where is that application filed by him?
By me.
No, that other person.
Copy.
IA number 1 of 2022 filed by LRs of dependent number. Which is that respondent?
Only one respondent.
No, there are two respondents.
No, here in 801 is only one.
801, you see that your past statement, there are two.
Yes.
What are you mentioned dependent number 1 and 2? Who is that now?
That's exactly what I was trying to mention. Respondent number 1, that is L. Mohan, is dead. As far as respondent number 2 is concerned, he is alive. He is on record. Avakal is already there for the.
Yes, the other respondent is there. Huh? So Narayan Street against the dependent number 1 was withdrawn by virtue of.
Withdrawn.
This has been withdrawn. Why you have made him as a party here? Why that you have stated in that you see that beyond that this thing past typing.
Suit against the dependent number 1. Yes, then why is necessary? Not a necessary party. Why not? Then what is your see, you need not follow what the office said. You have to raise that objection and answer before the court. Will go. Otherwise, I think the confusion. I thought that other one dependent is there. That is what that you can say forth before the court. Then yes, yes. LRs of deceased respondent number 1 has filed an IA 1 of 2022 to come on record. Or the learned counsel for the parties. IA 1 of 2022 is allowed. IA is allowed. The LRs of the deceased appellant number 1 is permitted. L1 is that L1 is permitted to come on record. Is permitted to come on. Learned counsel for the appellant is directed to amend the custody. She Dhananjay is undertaken to appear for. Yes. LRs. R1, A, B and C. Yes. Office is directed to show the name of Dhananjay M for respondent number A, B, C. What is that entry model granted? Yes, heard. Parties are directed to maintain status quo till next date of hearing. Yes. Now you amend that.
Final hearing matter, serial number 42 adjourned, serial number 43, MR irremated for appellant, SV Angadi.
Yes. Password. Yes. Both the matter, you are for whom? Where is the SV? Yes, password.
Serial number 45, Abhinay YT for appellant, Ranveer Pasha.
Yes.
March ಹಾಕಿದ್ವಲ್ಲ ಫಸ್ಟ್ ಮಾರ್ಚ್
Yes, what is the order we are challenging?
all possible.
On what ground you are challenging?
But it was traveling a train, not on the ticket.
That is, if he is traveling in, is a presumption that he is holding the.
He was holding a ticket in train number 12-640. But he was boarding it, that is going from Bangalore to Kattupadi.
No, ticket is belongs to that other train, but he was traveling in the different train.
Different, that is the main note.
But if he is traveling the train, then is it to be presumption or what is that law on that point?
That is, he is not a
No.
carrying, he is not a passenger on the particular train.
But where is that this thing? Finding of that, what is the finding of the footnote?
Pending up to pin number. Then 13.
Yes.
DRM report. Respondent is filed a DRM.
Application filed in support of their case. Respondent
Exhibit.
examined, respondent has filed so and so. Based upon the above conclusion, DRM respondent review board has, yes, 14.
14.
Yes.
Based on the above conclusion, DRM report exhibit D6, respondent argued the boarding a moving train is an offence as per the Railways Act. This is tried to board a moving train and invited risk of risky test. Thus, this act is to come under the self-inflicted injury with attracted section 124A B of the Railways Act 1989. Hence, the respondent need not to pay any compensation to the applicant.
Yes.
Applicant in particular argued for the decision had no intention to hurt himself about but process of getting seat in the general coach. He tried to board the moving train, which resulted said unfortunate incident. As such, this case does not come under purview of self-inflicted injury, which comes under section 124A B of the Railways Act 1899.
What is that 124 A B?
124A. Very exact.
That has come under. Such does not come under the purview of that SS. That is self-inflicted injury.
124A. Compensation on account of untoward incident.
But in other judgment, Supreme Court said it is a no fault liability. Therefore, it cannot be held that he has contributed to that negligence.
124A.
Yes.
When in the course of working a railway untoward incident occurs, then whether or not there has been any wrongful act, neglect or default on part of the railway administration, such as would be entitled to a passenger who has been injured or the dependent of a passenger who has been killed to maintain an action, recover damages in respect thereof. The railway administration shall notwithstanding anything contained in any other law to be liable to pay compensation. Such extent may be prescribed to an extent only for loss occasioned by the death or injury or a passenger is there such untoward incident, provided that no compensation shall be payable under this section by the railway administration. If a passenger dies or suffers injuries due to suicide or attempted to suicide by him, self-inflicted injury,
Yes.
his own criminal act.
Yes. Now you read this para 16.
Third, arguments both counsel, I find that applicants have successfully corroborated their case evidence RW1 and RW2, including DRM report, Exhibit D6, have corroborated the case of the applicant duly admitting the bona fide status of the deceased a bona fide passenger and his fall from train. So, the respondent argued that the self-inflicted injury and negligent act of the deceased result in sustaining injuries which lead to his death. As such, it comes under section 124A B of the Railways Act 1989 cannot be accepted to in view of the several rulings filed by the applicant and particular ruling held by the Honorable Supreme Court in the case of Jamila versus Union of India reported in so and so. In the case of Union of India versus Prabhakar Vijay Kumar and others reported in 2008 so and so, that negligence is not going to deny the compensation. Chapter so and so is of the Railways Act deals with the liability of the railway administration for death and injury of the due to the accident. Under the said chapter, section 123 provides for the definition class A and 123 3 defines
Yes, you skip
accident
all
to
this then.
mean an accident of the
Now you
nature.
come to that para 19.
In order to corroborate the relationship with the deceased applicant, have file the document exhibit before the tribunal. The exhibit A9 to A13 as well as the exhibit A15 corroborates that applicants or dependents legal heirs of the deceased, while exhibit A14 death certificate of Muttulakshmi, mother of the deceased, states that mother of the deceased has predeceased to the deceased. As such, applicant are considered as dependents as legal heirs of the deceased, for which they are applicant or entitled to statutory compensation of Rs 4 lakhs from the respondent railway administration, along with the interest thereon 6% from the date of the claim application till the date of the award. Thereafter, 9% till the date of the actual payment. From same of the light of the decision.
Yes,
Honorable
that is
Supreme
what
Court.
that is not, it is not your case that he is traveling some different train. You said that it is a self-inflicted injury.
It's what you the ticket, purchase the ticket from another train, but you is boarding
A contention in the, that is not that. Where is that contention? Have you,
statement it was shared AW1.
where is that? There is no such this
Statement of Radha Krishna, he was working in constable.
What is that? No, there is no any reference in that order. Yes, that's all.
You worship in exhibit punch. ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಮತ್ತೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಿ
ಎಲ್ಲಿದೆ
LCR.
No, where is your contention before that tribunal that he is not having any ticket? On the other hand, you have said that he was traveling, but he is rushed to that train. Therefore, he fell down.
The statement of the Radha Krishna is a working as the RPF in the study. Shall I read it?
So, where is the pleading that effect? No, that even in that this thing, it is not there.
RPF constable statement in the Madras worship, read it, worship. I am standing at the front. I am working in the above set capacity. So, train number 12639.
ಅಲ್ಲ ಈಗ ನೀವು ರಿಟರ್ನ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಆತರ ಹಾಕಿದಿರ
Rijected objection ಹಾಕಿದೆ kindly. Statement, reply statement. Para 5. Para 6 of 13. When the disease was alive, he was going to Katapadi to Bangalore City. Vrindavan Express train number 12639.
Which paragraph you are reading?
Para number 6-5. In our
paragraph applicant that on 20th disease was alive, he was going on Katapadi from Bangalore City by
train number.
Vrindavan trains. The journey ticket is false and is hereby denied. Further awareness to boarding the said train, Bangalore City. Australia, railway station, the skip accidentally fell down from that. Ticket deny Madi is
Next para 6. As per DRM report, this is try to board a moving train to the grab the seat in general coach.
That is not that.
Sustained a grievous injury resulted in his death. So it's one and the careless of the criminal act.
Plus, ticket number so and so is hereby denied. Only ticket denied. That's all.
Para number 9 next.
Last ticket deny madidira. But ticket is there.
Ticket is there. But is getting a train in another.
That one then in ground. Yes, that will consider by the tribunal. Yes, sir. This appeal is filed by under Section 23(1) of Railway Tribunal Act by the respondent, challenging order dated 28 April 2016, passed by Railway Claim Tribunal Bangalore on 28 April 2016, in application number 27 of 2014, whereby application is allowed, the compensation of rupees 4 lakhs has been awarded with interest. The facts of the case are that for the convenience, parties are referred to as per the ranking before the tribunal. The facts of the case are that on 26/11/2013, what is the name of the deceased? The deceased was going to Kattapadi from Bangalore city by Brindavana Express train number 12639 with a journey ticket. Hariharan. Yes. That while boarding the said train at Bangalore city's railway station, he slipped and accidentally fell down from the train, sustained severe multiple fracture injury and died on spot. The claimants are, who are the claimants? Wife and children of the deceased. I filed a claim petition under section 16 of Railways Claim Tribunal Act. On the service of summons, the respondent has appeared, has filed a detailed objection, has denied the averment made in the claim petition. And they have taken a contention that this was tried to board the moving train, invited the risk to himself, and he has died. After considering the evidence of both the parties, the tribunal has allowed that application and granted a compensation of rupees 4 lakhs with 6% interest. If agreed by the same, the respondent is before this court. So and so learned counsel appearing for the appellant has contended that the deceased was boarding a moving train and he invited a risk himself, and he slipped and fell down and suffered an injury and succumbed to that injury. Since it is a self-inflicted injury, he is not entitled for the compensation. It is not the fault of the railways. He further contended that he is not having valid and effective, he is not possessing the railway tickets to travel in that train. Therefore, he is not entitled for any compensation. The tribunal is error in allowing that application. Who is appearing for respondent? None appear for the respondent. Or the learned counsel for appellant. It is not in dispute. Hariharan died on 26/11/2013 when he was going to Kadapadi from Bangalore city by Brindavana Express train. While boarding the said train at Bangalore city railway station, he slipped and accidentally fell down from the train, sustained severe multiple injuries and succumbed to that injury. A specific case of the claimants that deceased was traveling in the Brindavan Express train 12639 with valid journey ticket. They have examined the witnesses who are they examined? RW1 ಅಂತಂದ್ರೆ ಯಾರು?
RW1
Your witness.
ನಮ್ಮ witness.
They have
Constable.
yes, they have examined
RPF
that
constable.
PW1, AW1. He has specifically stated that he was traveling with a valid journey ticket. Their evidence is corroborated by the DRM report. Trial court, the tribunal, after considering that evidence of AW1 and RW1 and RW3, RW2 and DRM report, has rightly held that deceased as a bona fide passenger traveling in Vrindavan Express train. The specific case of the applicant, that when he was boarding the train, it was in a rush and he was to rushing to boarding the train and he slipped, fell down and suffered injury and succumbed to that injury. The trial court has considered the provisions of section 124A(b) of the Railways Act has rightly held that after considering the judgment of Apex Court, even assuming that there is an negligence on the part of that deceased, the negligence is not in a ground to deny the compensation under the Railways Act. Even that Apex Court has, in case of so and so, has held that it is a claim under no fault liability. There cannot be any contributory negligence. In case of 2019 SCC 572, para 25 extract. In view of the above, there is no error in order passed by the tribunal. Accordingly, the appeal is dismissed.
Yes, it was. Traveling from Belgaum, Kataprabha to Belgaum was not a valid ticket or any possibility.
Holding possessing that is not a bona fide.
He is not a one of the passenger to the train carrying passenger.
What is the finding of the tribunal? This is railway to so and so, and along with the Sunil, Belgaum railway station. Incident so and so. He along with his deceased left with an house, got him a ticket at the.
There is no eyewitness.
Only paid towards the ticket, and it was computerized ticket and handed over to the tickets to the deceased. Wasn't aware where the deceased was getting the tickets and so on. So regarding that incident, children.
2010 to 2013.
With this examination coupled with the other which is available on records initiated lying on the applicant to show that deceased was in a passenger stands discharge. There is no contra evidence to respondent side discharging to show that deceased was not a bona fide passenger in this circumstance. No, that you are not denying that he was traveling in the train.
But RW1 clearly shows that RW1 of the passenger mission. Very low.
Yes.
2010 to 13. I was in train number so Haripriya Express from Kolhapur to Hubli. On that day, the said train arrived Kataprabha at 15 hours and they had stopped to 2 minutes and related to at 52.4. I was on the platform side. There was a normal crowd on the platform.
Yes.
All of a sudden, and a male person aged about 50 to 55 years tried to catch the moving train from the rear second compartment coach number so and so slipped and fell down. Immediately I applied the hand brake to stop the train and train stopped. I got down from the train and went to the spot and noticed that the said person sustained injuries. Immediately GRP and RPF personnel rushed to the stop and further verified whether he was having a ticket or not. But he does not have any journey ticket or platform ticket. Immediately I called the station master through walkie-talkie and he came to the spot and handed over to the injured person in the presence of.
So any other side is there. It requires to be hearing of other side. Yes, none appear for the respondent. Please this matter of to it. Yes, madam.
I appear for the respondent, your lordship.
Yes.
Involved in this matter, my lord,
It will be concluded by another 10 minutes.
has to be.
Yes, we'll have it next week. Yes, at the request, release this matter of 1 week.
Please, your lordship.
ಯಾವ matter ಅವರು process ಮಾಡ್ತಾರೆ. Yes, where is that? He is not there. Next week, huh? Yes. Appear for the appellant, release this matter 2 weeks. Where is your opponent, Mr. Rai? Next week. What is that? Your application is dismissed. Why?
The AW1 father and AW1 Narsimraj friend of the deceased, they are not the eyewitness at the time of the.
Now that what is that material to show that he was traveling? He has having a valid ticket.
But there is a ticket.
Then deceased was combined their native place. Deceased didn't carrying any luggage. He came now to the deceased. Purchased the ticket. They are traveling together in the same train. Support of the contention applicant so and so. DMR investigation report supported their where it concluded that from the above journey it has come to light there was no evidence to say that they were traveling by train. None of this notice deceased person falling from the. There is no evidence to that you have fall from the train. No ticket.
They have taken the contents in the police records, my lord, as well as the case diary shows that, he is the passenger in the train, my lord. The father is not eyewitness, one of the Narasimhan, but father eyewitness is
No, you need not be eyewitness.
Please,
What is that police charge sheet says?
charge sheet says that, my lord, even charge sheet and police record diary, kindly see, my lord, police diary.
No, they have filed in a charge sheet.
Please,
What is that charge sheet say?
charge sheet shows that, my lord, death, my lord, due to the injury and the kindly see, my lord. Yeah. Postmortem report shows that, my lord, kindly see, my lord, yeah, postmortem report.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಪೋಸ್ಟ್ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ ಏನಿದೆ?
Postmortem.
ಏನಂತ ಹಾಕಿದ್ದಾರೆ?
Kindly see, my lord, death is due to the shell of hemorrhage as a result of which multiple injuries sustained.
ಅಷ್ಟೇ, ಟ್ರೈನಿಂದ ಬಿದ್ದಿದ್ದಂತ ಇಲ್ಲ. ವೇರ್ ಇಸ್ ದಟ್ ಚಾರ್ಜ್ ಶೀಟ್?
A9 is the ticket.
Huh?
A9 is the ticket.
Ticket you have produced.
Please, my
But
lord.
court said no ticket has been produced.
Adane,
Where is that?
A9, next ticket is also after the postmortem.
What is the finding of the tribunal regarding the ticket?
Kindly see.
No,
Waiting
but
up.
they are saying that you are holding the ticket, but you are not traveling in the train.
That is their difference.
Yes. What is that?
Kindly see,
Pass ido, employment card.
Car number 14 of the judgment.
Yes. No, that where is that charge sheet that will support your case?
Is diary, my lord, kindly see case diary.
Yes, diary ಅಲ್ಲ ಇದೆಲ್ಲಿದೆ? ಪೊಲೀಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಣ್ತಾ ಇಲ್ಲ. That is the crucial documents. If your police has filed a charge sheet, they are not challenged. ದಿನಕ್ಕೆ 73 ಸಿಗುತ್ತೆ ಠಾಣೆ 40 ವರ್ಷ ಸೊ ಒಂದು ಡೆತ್ ಇಸ್ ಡ್ಯೂ ಟು ದ ಶಾಕ್ ಅಂಡ್ ಬೆನ್ಸೆಂಟ್ ಶವ ದೊರೆತ ಸ್ಥಳವು ಸನ್ನಿವೇಶ ಪರಸ್ಪರ ವಿದ್ಯಮಾನಗಳಿಂದ ಹಾಗೂ ರಿಪೋರ್ಟ್ ಹೇಳಿಕೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ತುಮಕೂರು ಧರ್ಮಸ್ಥಳ ರೈಲು ಗಾಡಿಯಲ್ಲಿ ಬರುತ್ತಿರುವಾಗ ಅಥವಾ ನಾನು ಪ್ರಯಾಣ ಮಾಡುತ್ತಿರುವಾಗಲೇ ಮೇಲುಪಟ್ಟು ಅನುಮೋದನೆ ಕೋರಿ ದುಡ್ಡಿನ ಹಾಗೂ ದುಃಖದ ಮರಣವು ಯಾವುದೇ ನಿಷ್ಪಕ್ಷೆಯಿಂದ ಭಾವಿಸಿರುವುದಿಲ್ಲ ಎಂದು ಈ ಪ್ರಕರಣ ತನಿಖೆ ಮುಕ್ತ ಮಾಡಿ ಆಕಸ್ಮಿಕ ಬೆಂಗಳೂರು ತುಮಕೂರು ಬರುವಾಗಲೇ ಬೋಗಿ ರಾಯಿಸಿಟ್ಟು ಅದು There's a FIR that he has felt from the train. Where is your opponent? None appear for next week. Started in or Bandra Atnimsha, you can just ask them to present next day.
Monday.
Not Monday. Tuesday. Tuesday. Yes. Yes, at the request, none at the request of the appellant, release this matter next week. Yes. Appellant? Yes. What is this, Mr. Krishna?
Partition suit in the Grand Court, there are 8 properties. The serial number, the property serial number A, B, C, and the H is G is concerned. We have consented that it is the ancestral property. Regarding EF and EF, EF and
So that you
EF
are
and H is concerned, it's the self-acquired property of the respondent 1 and 2 hearing.
no, that your suit for partition has been dismissed.
No, it is declared whether the respect of the schedule A, B, C, D, and G is concerned. And E and FH is concerned, their claim is rejected because
That they are the self-acquired property.
self-acquired property of the respondent 1 and 2. Initially, the appellant has filed the suit for partition. When we filed the statement, the written statement admitting that there is the other 3 properties are ancestral property, we have no objection, let them do partition. And regarding E and F and H is concerned, it is a self-acquired property. Then he filed the memo for withdrawal of the suit. Then by that time, the other defendants, they transposed themselves and they fighted the case. Now the person who has filed the memo for withdrawal of the suit, he filed the appeal. And other daughters, they admitted that that is the self-acquired property of the respondent 1 and father and mother. They don't have the claim on that, and we have only claim on the ancestral property.
Now the trial court said that it is a self-acquired property.
Yes, 3 properties concerned self-acquired.
What is the documents they have produced?
They have not produced any document. Even the appellant has not cross-examined the PW1, where PW1 categorically said that the 3 properties are ancestral, self-acquired property of the respondent 1 and 2. That question, the appellant is not cross-examined by the appellant is not cross-examined in the PW1. And he also not produced any document. He admitted that it is the time.
Your case is that is a self-acquired property of you.
Yes, ma'am.
How you have acquired that property?
I am thrown out from the family when at the time after my marriage, because I have conducted an intercaste marriage. After that, I have gone separate, and from my earning, I have purchased 2 property.
No, what were you doing?
I was doing some milk vending business and the nursery business and some other business. And 1 property is purchased by the wife of the second respondent by the fund by selling her jewelers and from the contribution from her parents.
That you have established by.
I have established. And that is also admitted by the other respondents, also admitted, except the appellant hearing. The appellant also not produced any document stating that he admitted that at the time of the purchasing those property, he was a minor, and 2 properties purchased when he was not born at that time.
Who is that your opponent? Vijay Shankar Gowda. Who is that? What is that? Is there an interim order?
No interim.
That final degree proceedings has been drawn.
No, not at there.
Permanent consequence directed to furnish a complete appeal memo. When you proceed for final degree, they will not come at all. No representation. None appear for the appellant. Leave this matter after 2 weeks. You proceed.
Serial number 43, for appellant, SB Angadi.
Yes. None appear. Yes.
ವಿಚಾರಣೆ ಯಾರು ಇಲ್ಲ. ಅವ್ರು ತೆಗೆದ್ರು ಅಲ್ಲಿ ಏನಾಯ್ತು ರಿಕಾಲ್ ಅಂತ ತೋರಿಸ್ತಾ ಇಲ್ಲ. ಬೆಳಗ್ಗೆ ಆ ತರ ರಿಕಾಲ್ ಅಂತ ತೋರಿಸ್ಬೇಕಾಗ್ತದೆ. ನಾವು ಅವ್ರು ಬಿಟ್ರೆ ಇನ್ಯಾರು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಯಾಕಂದ್ರೆ